13
এই কার্ড এটা ছেড়ে দিয়ে গেছে এই কার্ড ট্যাব আছে কার্ড ট্যাব আছে
Yes, Mr.
Will
Tiwari.
not, direct the regional passport authority will not to take decision. Will not, actually will not, whatever will not, the police report was not available. Now will not, they are saying the police report is available. So will on the basis of the police report, let the will not, regional passport officer will not decide the issue.
Lordship, may I place the relevant portions of the
Nothing
matter?
required. I cannot take a decision. It has to be taken by them only.
Yes.
Lordship,
police report says.
Lordship, it is at the stage
I
of
will not
police
take-
verification.
Very well, whatever it is, now if the police verification is with them, whatever decision
Lordship,
they
the
are,
police verification with the state authorities.
they will
Lordship,
submit it if it is
They will
with them.
submit it.
They have already submitted a report.
For me, it will not do. It has to be submitted before them. I will direct them to submit it immediately, maybe in 2 days. And thereafter, the authority will take decision in
Yes.
accordance with law.
Yes, yes.
Lo-
Response number
Lordship,
3. Response number 2.
may I only indicate here, Lordship, this was kept pending from 2024 December.
So therefore, I cannot direct the passport authorities to issue passport. That is a decision which
Lordship,
has to be taken
Lordship,
by them.
even my prayer is not that. My
Even
prayer
that
is
is-
only to overcome the stage of police verification.
Very well, they will submit the police verification before the authority.
Lordship, may very kindly peruse the report.
Yes,
with-
I will not direct this report to be form a part of the records before the passport authorities. It has to come before the authorities in accordance with the procedure.
Yes.
The police authorities, if they were lax in not submitting the report till date, they will now do it within 2 days. from
Lordship,
the
then
date of the
kindly directs the police authority will expedite
Yes.
in
I will
submitting the
immediately
report
say
before
that
the
they will do it
authority.
within 48 hours. from
Lordship,
this. That should
Grateful,
do.
my lord.
that can be done my lord so far as we have taken instruction these were erstwhile dispensation these are all politically motivated cases my
So
lord.
now the police report has been filed here also.
Lordship, and it clearly states that no warrant is pending against the petitioner as on date. So there remains no, there is no obstruction in allowing the police verification. Thereafter, the passport will go to the respondent number 3, 4, whoever it is. The police verification is carried on by the state police authorities. There, the passport authority has nothing to do.
Very well. लिखे नहीं. This
Lordship, kindly grant a pass over.
Passed over.
Yes,
Next.
obliged.
You are appearing, Mr. Mukherjee. Again, none appears for either of the parties. Same order. Next.
My lord, I am for the item number 4, my lord.
Yes.
4. Yes.
देखिए,
My lord, service is not effective. I am praying for not this week.
taken in. Learned advocate appearing for the petitioner submits that service taken in. None appears for the petitioner.
The last order it is written that it will be dismissed.
Yes. वही आगे डेट
Milord, I am for the petitioner. Milord, for the time being, Milord, let this matter go out of list. I tell your lordship, Milord, the first writ petition was filed by my client for new connection. Now, Milord, that order was allowed. Now, Milord, this is Milord, since there was resistance, a second writ petition was filed for police help. Now, Milord, from that order in the earlier writ petition, Milord, some of the parties have gone to division bench, matter is pending. Milord, some of the parties, Milord, from another connected matter, Milord, SLPs are pending. As of today, Milord, if I move this, Milord, this would be, Milord, let it go out of list, Milord. I am for CSC.
ওই ডিসমিস ফর ডিফল্টের অর্ডারটা হবে, ওই ডেটটা চেঞ্জ হয়ে যাবে, এখানে জুলাই
Matter on behalf of CDCL. I'm just praying for a short Passover.
ফার্স্ট ওভার
Passover. Well, not today. I was busy with the other beings also.
নট টুডে
Not today.
Your Lordship, on behalf of the petitioner, Your Lordship, there is the affidavit of service.
ইয়েস
Yes.
My lord, I am pleading on behalf of bank and I am opposing, my lord.
জাস্ট আ মিনিট ইয়েস
Your Lordship, as per the last degree direction, we have already served the copy. And now the matter is about that the petitioner, that is being a trader of marble and having another associate things. And what happened in the year of 2019, I am facing some financial difficulties. And I go to the respondent, means the Canara Bank, Your Lordship, for some OCC, Open Credit Cash Facilities. And then after, in that 2019, it is mentioned that the Canara Bank, that is a financial facilities giving the general public, including traders, to meet their working capital requirement, Your Lordship. And in year 2019, they give me the OCC. After that, in the year of 2021, they renewed my loan account, Your Lordship, and it is mentioned that I give the particular EMI without any default. Now, my humble prayer that I want to close this account, Your Lordship, and on the several occasion, I have already made several representation to the bank account, but they did not give a single reply, Your Lordship. So my humble prayer is, Your Lordship, first that is give the direction to the respondent authorities to immediate the investigation over the representation, Your Lordship. Kindly see the page 22, Your Lordship. Here is my representation, Your Lordship. And one more prayer, Your Lordship, that is, yes, commanding them to take necessary action and close my loan account, Your Lordship.
loan account will be closed if you pay the loan.
Yes, Your Lordship.
It's as simple as that.
Yes,
If you want installments that I cannot direct, there cannot be a mandatory direction. You can make a request, they will consider in accordance with
Yes,
law.
Your Lordship,
Whatever.
then-
If they say yes, it is yes. If they say no,
Lordship,
But-
I am not capable right now to bear that all amount. I am ready to
make a
give the,
representation, you
print-
made a representation, dispose of this representation.
Your Lordship, then give the direction to consider my representation and give all the
I will
details.
say that I am not making any mandatory direction. They will not be bound to enter into an OTS. That bank, the court cannot direct. It is between you and the borrower. If you have made the representation, they will consider it. Whatever they say, if they feel right, they will allow. If they feel it is not right, they will reject. It's
Your
up to
Lordship,
them.
On the several occasion, means on the previous occasion, I go to the bank. I say, please close my account. Please give me some opportunities. I am ready for one-time settlement, Your Lordship, but did not give it a
That
chance.
court cannot direct. One-time settlement is not a right.
Yes,
That has to be done by the bank according to the bank's norms.
Your Lord.
Consider it and
My lord,
dispose of.
OTS, they are asking for OTS. OTS only. on
Very well,
account
you
of
say it is not, say I will not give, or your
Yes.
representation,
But
say
the
whatever,
net
answer,
banking
sir,
account-
answer it, answer. to-
Yes, at least
Net
consider
banking
my
account,
representation,
entire
Your
amount
Lordship.
they knows. What is the amount, the dues?
Very well.
We are ready to settle, my lord. We'll go before the.
But they did not give
That
a
is what I
single
am
reply.
directing. That is what I am looking.
And also, Your Lordship, kindly give
That I am appearing for the respondents, my lord. Not respondents.
My lord, I'm led by Mr. Pan, Advocate Pan. He is busy in other court. Kindly pass over, my lord.
Pass over.
But he said 1 p.m.
1 p.m. 1 p.m.
No, 1 p.m. 1 p.m. will not do. He said 1 p.m. if it is not taken up. Now it is taken up. He is
No,
not there.
my lord, he has instructed me to pass over for 1 p.m. My lord.
Why? He cannot take it according to his will.
Yes,
He said 1 p.m. because he was in doubt whether I'll be reaching 11 or not. Now I have reached.
now he is busy in other.
This can't be the way. It can't be 1 p.m. then.
Coming, my lord, my lord. He is coming, my lord.
Pass over.
Next call. 12 কেন কল করছেন? 12 to 12 নুন আছে। এটা কেন দিচ্ছেন? 12 বারবার দিচ্ছেন আপনি। Yes.
এটা কত হতো? 13?
13.
Now kindly hear me 2 minutes time. Now, the petitioner will file the suit for eviction and permanent injunction. The suit was decreed in the year 1988. Now, the decree was put into execution in the year 1989. During the pendency of the execution case, now 147 application was filed, that was dismissed. By some other party, order 21, rule 97/200 application was filed, that was also dismissed. Now, the police cost was assessed, that cost was also deposited. Subsequently, when the date was fixed, my lord, for the execution of the decree, just 2 days before, now some other parties filed an application under order 21, rule 97, containing inter alia that the petitioners executed a sale deed in the year 1988. That was found certainly in the old Almira in November 2025. That's why they filed an application, and also an application under order 51 that was state entered execution case was state. Now that was challenged before your lordship. Now your lordship's order very important. Kindly see your lordship's order, page 122. The relevant paragraph, my lord, from paragraph 4, page 123, paragraph 4.
Yes.
When I am reading that order, having heard the learned advocates appearing respective parties and having considered the materials on record, this court finds that the learned trial court was not at all justified in putting off the execution case completely upon the filing of the application under order 21, rule 99/201. Without first considering the merits of the application. We must remember that the resounding words of the Honorable Supreme Court in the case of this versus this, the Honorable Supreme Court has observed that an active judge is the answer of irresponsible lawsuits, and that the court should endeavor to ensure that bogus litigation is shut down at the earliest stage. Although the said judgment had been rendered in the context of a frivolous suit, yet there is no reason why the same caution and attention commanded by the Honorable Supreme Court to be exercised in the suits cannot and should not be applied to application under order 21, rule 97/201 of the Civil Code of Civil Procedure. In order to weed out the date would at the threshold. No reason has been assigned by the learned executing court to justify the order of stay of the execution case. The learned executing court has, after summarizing the facts mentioned in the application filed by the opposite party, only mentioned that the opposite party have made out a arguable case. There is nothing to show why and how the case was arguable. The factual summary does not show anything.
Yeah, I have read it.
My lord?
I have read it.
Now, subsequently, my lord, after this order was passed, 2 applications was filed for addition of party, one by some Mullah and some Rai. That application was subsequently not pressed. I have annexed this order. Subsequently, again, one Rai filed an application for addition of party. One application was filed for impounding the agreement, sale agreement, and one application was filed for, my lord, adopting the plant. 3 application was allowed. 3 application was allowed. This is the impugned order, and in the order specifically stated, until this James case is disposed of, execution is not being questioned, is not being touched. Now, my lord, your lordship's order, if the James case is not being disposed of by 11th June 2026, the execution has to be proceeded. But this order, in fact, my lord, has not been given in importance. Rather, the addition of party application which was not pressed, subsequently that application was allowed. And
Where
19.
is the order by which
Well,
it
kindly
was
see
not
this
pressed?
order. The order impugned, order number 219, 8 June 2026.
Page?
And this is the entire order. I have not given page. Order 219, 8 June 2026.
Nine. 219 is the impugned order. I want to see the order by which it was not pressed.
The addition of party was not pressed. This order, I am giving that order. 126 page.
Page 126. Page 126.
May I kindly see order number 210? Today is fixed for hearing 2 applications under order 210 of the CPs and advocate petitioner file urgent and not pressed 2 petitions.
The same person had filed.
Same person filed.
Yes, Mr. Rai, if he had not pressed without liberty, how could this application be maintained?
Your lordship, I can turn to the order impugned, my lord will find.
Yes.
This withdrawal, my lord, if your lordship can consider, this application was withdrawn by a person who was initially filed an application order on written the application. আগেরটা তো না এটা এটা 5620.
Yes, Mr. Rai.
Yes, my lord. ওই অ্যাপ্লিকেশনটা কোথায় গেল রে? মানে দিস ইজ দ্য অ্যাপ্লিকেশন which এটা মনে হয় নেই এর মধ্যে। দাদা এটা তো দেই। এই অ্যাপ্লিকেশনটা আছে অ্যানেক্স করা দাদা?
হ্যাঁ, অ্যাপ্লিকেশন আছে।
আমি পাইনি। It is why. এইটা জজ সাহেবকে আছে।
Yes.
Now, man can turn to their objection, page 142.
Yes.
The specific objection which was taken, my lord, kindly consider.
Objection, Mr. Rai, even if it is not taken. This is
No.
a rule of public policy. If you have filed an application, you have sought to withdraw it without leave to file afresh. By rule of it is not res judicata which applies, but it is a rule of public policy. Sarguja Transport, 87 Supreme Court, all of us.
Constructive res judicata.
Not even constructive res judicata. Public policy is the expression which has been used by the Honorable Supreme Court, although in a case of a writ petition, saying that even Order 23 Rule 1, these principles are principles of public policy where res judicata will have no application, but a person cannot come up to the court according to his will. He will file, he will withdraw without without leave to file afresh. He will file again. That is not the law.
Who have filed this application, my lord?
Whoever has filed it, his son is a party to the proceeding.
No, Kalipad Rai was not the party. That is why.
Kalipada Rai's son is a party to the proceeding. I have seen the application. In the application, he says that he got knowledge on 4th of June.
Yes.
That is the averment. And his son is a party to the proceeding. I have seen that in the objection, they have said that he was indicated as dead. That was the objection at page 142, which you just now showed.
Yes. If you logically consider the portion, তার পিতা শেখ আসাউদ্দিন মৃত বলিয়া শেখ রাজু তার পিতা শেখ মালু মৃত বলিয়া শেখ সাদত পুতুল দাস উল্লেখে যে বিশ্বাস উত্থাপন করিয়াছে। My lord, what is the relation between this Malu and this Rai is unknown. Be as it may, my lord.
সুরজিৎ রায় তাহার পিতা কালীপদ রায় মৃত বলিয়া উক্ত যে মিসকেস মোকদ্দমা করেছে। সুরজিৎ রায় is your son.
Yes. যে তার
Party
পিতা
to the proceeding, you are unaware of the proceedings.
এটা বলুন তো।
Is it your case that your son has suppressed the fact? Your son you claim adversely to your son? Is that your case in the petition under Order 1 Rule 10? How can you
He
suddenly?
is one of Kalipad Rai is one of the signatory.
Maybe Kalipada Rai should have come then if he was one of the. Why did he withdraw the application that he had filed earlier?
My lord, can you consider if the son filed this application?
Son has not filed. I don't know who has filed who has
Yes.
filed the application. The earlier
Application for addition of party,
Yes.
Malu and Kalipada Rai.
Where is that? Show me.
Earlier application.
Yes.
When I have stated in paragraph 3,
Paragraph 3 of
in my petition.
Again, application.
he says he has not filed. Mr. Rai says that Kalipada Rai had not filed.
Kalipada Rai and Malu has filed two under Order 1 Rule 10.
But his case is that the earlier application was not filed by Kalipada Rai. You have a copy of the earlier application?
Kalipada Rai application.
You also don't have, Mr. Rai.
No, my lord, I have to. That application copy I have instructed by Julia to bring. I'll take it tomorrow, day after tomorrow, I'll bring it.
Can you see paragraph 3? Can you see?
Paragraph 3 of
My petition.
revisional application or
Yes.
Revisional application.
yes. Paragraph 3.
এটা কি আছে? এই অ্যাপ্লিকেশনটা কোথায়?
In the same James case, big numbers has one Sheikh Malu and one Sheikh Kalipada Rai filed an application on such and such for additional party under Order Rule 10 of the Civil Procedure Code. Containing entails that they were
Yes, there is an aberrament, Mr. Rai. Show me the application. Can you bring it tomorrow?
tomorrow I
Or today also, if you can bring it, I will pass it over. If you can bring it today.
let it be taken at 2 p.m. I'm through WhatsApp.
Then bring it. They take it tomorrow. 2 p.m. will be difficult. Original.
Tomorrow 2 p.m. my lord, that better.
Which one? It is today.
Yes.
But the second application I have
Have
annexed.
yet.
Second application I have.
Dear Lord, my lord.
Second application I have there. He has also handed up a copy. Second application is there. We want to see whether the first
First one.
application, what was the. Can we have it tomorrow? What is the problem?
Yes.
Let us have it tomorrow. Liken it.
My lord, tomorrow, my lord, one of my close friends' mother is going to operate. Tomorrow, my lord, I'm only praying for tomorrow. Today, I have no problem. You can bring.
But
What day after
I'll take
tomorrow?
it at 2 p.m. I will be bringing that.
ঠিক আছে 2 p.m. pass over কেটে দিন অর্ডারটা কেটে দিন 2 p.m.
If it is not, my lord, then what is? If you can bring.
I will bring that.
2 p.m. Yes, কি এটা আইটেম 14 আইটেম 14 দেখাচ্ছেন কেন হয়ে গেছে তো 14 দিদি দেখে করুন লিস্ট গুলো দেখে করুন
Please, Lordship.
লিস্টগুলো ভুলভাল আমাকেও ফাইল দিচ্ছেন আর ইয়েও দেখাচ্ছেন করবেন তো
করবো না তো।
Very good. Yes.
My lord, I am for the petitioner, my lord. Petitioner line has been disconnected on the ground of pilferage. My lord, there is allegation of theft and provisional order passed by the CSC authority 3,43,964. Last page. But our consensus is that CSC authority on the complaint of petitioner rectify the line and thereafter started getting the connection. For that, we have supplementary written notes of argument. Only calculation will be 52 days. They are usually calculated 365 days. Here the electricity line was burnt and it was out of electricity. Thereafter, they restored the line. We made complaint to the local, to the CSC authority. That is we have stated that for that last annexure P3, page 18.
Yes.
On the basis of that they restored the electric connection. For that, and restoration is the second paragraph. There will be calculation of 52 days. We are ready to pay the said amount. That is our case. And for that, written notes of argument, I don't know whether I have supplied it. But only 52 days there will be calculation because the entire line, electric line of the premises modified and restored. So only these 52 days will be their calculation. We are ready to pay that up.
Yes, but even if that is there, 52 days or 365 days
after restoration.
Why before the writ court? Why not before the appellate authority?
My lord,
why is this not being agitated before the
we have stated before the assessing officer, we have stated they have not accepted. And final order তো পাস করুন
সব হয়ে গেছে বলে
তো
দিচ্ছি
আমাদের কাছে কিছু নেই
না কিছু নেই বললে হবে সব
দাও,
হয়ে গেছে।
যদি দাও আমি দেব।
I tell you, Lordship. May I?
You have given your copy of written notes to him.
Yes, everything has been. Now they are supplying the written notes and argument
No.
that has not been supplied to me. But I am not that. I am ready to argue on that. If your Lordship kindly allow me, then I will submit. May I, subject to Lordship kind approval?
Happy to be on behalf of final order of this. আটটা হলো না, ডেকে চলছে।
Yes,
Now, your lordship, kindly see.
you have not
Uh,
preferred appeal.
No,
My lord,
You have not preferred appeal.
before that, we filed this writ petition.
Yes.
may I? In pursuance to the direction given by the Honorable High Court, we have filed the affidavit in oppositions as well as written notes on argument. I draw your lordship kind attention to keep side by side the written notes on argument as well as my affidavit in opposition. Lordship, kindly take note the list of the dates which are very much important for consideration of this instant case. Lordship, this petitioner, there was a pilferage on, that is at, your lordship will find, that is from paragraph 4 onwards, that I have stated in my written notes on argument, that has taken place on, may I, sir, lordship, that is on 16/12/2025. The allegations of supply which has been made by my learned friend, that has been made prior to that. This point has never been raised before the assessing officer for considerations. But I have already dealt with that. So the final order of assessment has been passed on 29/12/2025. Against that, your lordship, no appeal has been preferred. It is an admitted position. And lordship knows that so far the point which has been they have raised afresh here in this writ petition, that cannot be taken into considerations subsequently, lordship. Now, lordship, kindly see my written notes on argument for a moment. May I place it subject to lordship kind approval?
Just give me the point, John, read it.
Yes, yes. The lordship, kindly see paragraph 4, that the point which has been taken, that in, lordship, kindly come to paragraph 4, page 2 of my written notes on argument, that in respect of paragraph 3 of the said petition, the respondent state that new plea has been taken on behalf of the petitioner without any basis. The vague plea was never
This
taken.
point you have just now argued. that
Yes,
this
yes,
is a new
yes,
plea.
yes. Now, what happened, lordship? This is the point, and next, lordship, will that in a paragraph 5, lordship, kindly come. The petitioner and or representative was given fullest opportunity of hearing as specified in section 126 of the Electricity Act. The assessment has been calculated as per regulation. I have annexed that regulation in my written notes on argument. And lordship, kindly come to that, the next paragraph 6. I have stated that the reasonableness of the reason given by the assessing officer in the final order of assessment after granting opportunity of hearing cannot be gone into with deepest respect into this writ court. That the judgment I have already annexed before your lordship. Lordship, kindly come to this judgment AN 2020-1878. That the scope under Article 226 has been specified from paragraph 9 onwards. That is at page 17 of my written notes on argument. Lordship, got that?
Yes, yes.
Lordship, here, lordship is well aware this BC Chaturvedi case, and lordship is well aware the further there are series of judgment on that. Here it has specified that 3 judges were held that power of duty is not an appeal from a decision but a review of the manner in which the decision is made. Power of duty is meant to ensure that in your receive the fair treatment and not to ensure that conclusion which the authority reaches is necessary correct in the eyes of court. So my humble submission before lordship, fullest opportunity has been granted to the petitioner. At that point of time, they never raised this issue, so that the assessing officer could get the opportunity to deal with that point. Now, admitted position, they never preferred any appeal against that. And on that basis, if your lordship kindly come to page 19 of my written notes on argument. Lordship, got that? The scope which has been specified under Article 226 and 227. So my humble submission before your lordship, at this juncture, in this writ court, no relief can be granted to the petitioner.
And what about the decision which he has cited with his written note?
Which decision? Which decision?
You have cited a decision with your written note.
I have cited.
দেখো রিটেন নোটস
বাবা আমি তো জানি না কি
বুঝলাম, হঠাৎ এসে গেছে।
রিটেন নোটস
may I what is the decision may I know?
রিটেন নোটস এর কপি দাও না
না আমার দাওনি written notes on earth. But I'm just give 1 minute. I'm dealing with that.
এটা তো একাডেমিক রিপ্লাই রিটেন নোটস
সকালবেলা ধরিয়ে দেয়।
ও কৌশিক চন্দ্রের
But this decision has got no application in the instant case. Why I'm telling you, Lordship? But so far, this judgment, no decision has been referred of the Supreme Court. It's a par incuriam judgment. And so far, Lordship will kindly appreciate the situation that the fact which has been specified here, so far the time, it is within the domain of the assessing officer, Lordship. So far, this fact cannot be gone into by this writ court, Lordship. This is my humble submission. This has got no application in the instant case. Hey, আমাকে written notes দাও copy.
Why don't you prefer appeal, Mr. Halder?
That liberty be given.
Prefer
That
appeal,
liberty be given.
take all points.
হ্যাঁ মাল।
Now it is very, very well settled now. Judgments have
Your Lordship is well aware about.
very well settled now. This
was running from court number.
He is also there.
Yes.
Let it be taken up then. Mr. Naik, please wait. This was passed over.
11.
11 take to call.
The last official lawsuit asked me whether possession has been taken over or not. Kindly turn to page 100 of my petition, wherefrom it will be clear that the entire possession was taken over. Kindly turn to its joint dispensary report. At page 100.
Page 100.
Yes, last paragraph. Again, it is to mention that 5.0527 decimal of case land was handed over to the Metro Railway on 3rd October 2019.
Yes, so this was in 3rd October 2019. That was the
19.
old. So that the measurement is proper, whether it is
No,
from your
measure
land.
handed over, possession handed over.
Yes, the
So
possession
they are
and-
enjoying the possession.
Mr. Pan, either I am not able to
My lord,
express myself
sorry,
to you.
sorry.
The possession of 5 acres or whatever, let us keep it simple, 5 acres of land, if I say,
Yes.
has been handed over to you. Your case was that instead of taking the entirety of 5 acres from my dag, it has gone from someone else's dag.
Mine.
That was your case.
Yes.
So therefore, they are in possession of that 5 acres. But the question is whether the entirety of the 5 acres is from your dag or from some other person's dag. Now, this says that in 2019 it was handed over. If in 2019 it was handed over from your dag or from other person's dag.
No, what happened? My lord?
Because thereafter it is clarified. Hence, the joint now and the present measured area is less than such and such. So, if it is less than such and such, then that means that although the aggregate measurement of the land is 5 point something acres, but from your dag, only a lesser area has been taken. The balance area has been taken from some other person's
My
dag.
lord, my
That
lord.
is the meaning.
So, yes, my lord, what I am on is this, my lord. That's why I submitted it to your lordship, my lord. Kindly remand it back to the authority.
I will make it clear. Even if I remand back, Mr. Pan, let it be understood. I'll clarify that if out of the entire land which was sought to be acquired from you,
yes,
in terms of the award,
yes,
you are in possession of any portion of such land, that you will have to vacate. You cannot be in possession of that land.
My lord, taking from my client is here, take undertaking that I am not in possession.
No, very well. I will, since
Yes.
this is a factual,
Yes.
this is a factual
yes.
thing. I will,
Kindly record that.
I
Kindly
will
record
record
that.
that you will have to vacate.
Yes.
And
Yes.
they will take possession of that land.
Yes.
So far as that other portion of the award is concerned, where he has directed, there are 2 problems here.
Yes.
An appellate authority cannot direct the competent authority to pass an order in a particular way.
Yes.
He is independent. For example, High Court cannot direct the district judge to pass a particular decree. High Court cannot say, you pass this decree. What the High Court can say? High Court will say, you consider it in this way and pass a decree. Now, what has he done? He has done, you are directed to correct and rectify the
Giving
mistakes.
observation, my lord. On my humble understanding, my lord, after giving observation,
He cannot do that. He cannot do that. The competent authority is an independent authority to take decision. Whether it will correct or not, whether it is arithmetical error or not, that decision has to be taken by it. He cannot direct, yes, you do it. He cannot do it. He is passing the award. He is correcting the award. That he cannot do. But yes, here again, Mr. Pan, since there is an order passed by the competent authority, say for example, let us take this hypothetical situation. Metro also could have approached the competent authority by way of very well it is maintainable, not maintainable is a different thing. It could have approached independently by way of an application saying you correct the award. Now, if it had approached by way of an application and it had passed an order of correction, that order would again have been subject to challenge before the appellate authority. It may be a wrong order, set aside. So going by that logic, this order also needs to be separately challenged. Now, on the last occasion also I indicated that if it is not challenged before the appellate authority, say you said appellate authority is not accepting your appeal. You can challenge it by way of other means known to law.
That steps I am taking. Not only that, what I am on is this.
So I will not make I will say that this is illegal.
Yes.
I will also observe that any step which may be taken on the basis of this will not inure to the benefit of the, but you will have to, I will
Yes,
also
yes.
observe that if any step has been taken, you will be free to challenge the same.
You will also be kind enough to direct the appellate authority to, because appeal is lying ready with me. Well, that may be accepted by the
I will,
appellate
I see,
uh,
day before me, there is nothing in
very well,
writing.
very well.
saying
I
that
will
it
text
is
it. I will text it
Yes,
second time.
I'll just answer. Malad. I have followed Malad, what is following from my lordship, Malad. Malad, only thing, the fact remains, I'll just indicate 1 or 2 points. Malad, the fact remains, 2019, the possession was handed over. The claim was awarded and paid, accepted. No challenge, nothing. After 5 years, an application has come up. On the pretext, Malad, this is an admitted position. Admittedly, it has been stated clearly that a wrong portion has been handed over in terms of the inspection and the order. So this has been sought to be clarified before the competent authority, and it is the specific case of the petitioner that the competent authority or the competent authority has the power to invoke 16B, the provision of 151 of the code. That is the specific case. And it has also been, now the competent authority has turned down the case on the ground of maintainability, that it is beyond the time limit. No one has come for, well, I can place the
Yes,
order.
no, you please go
Yes,
ahead.
yes, please. Sorry.
I understand.
Sorry.
You don't need to go back. I have understood the facts.
Sorry.
Yes,
It will
now,
unnecessarily waste time.
now in this situation, thereafter an appeal has been preferred. Now in the appeal also, and loads of argument has been filed saying that the court appellate body has got the power to invoke 151, and they want to, my lord, it is a deposition I have handed over on the last occasion. It is a admitted position that they're willing to hand over the money which has been paid in excess. So there is no dispute so far this part is concerned. My lord, good, bad, indifferent, my lord, what has been, my lord, placed and recorded in the appellate body's order, section section 152 and the power of section 152, that matter I am not going into, because that is something, well, so far this part is concerned, the possession, the quantum of the money which has been paid in excess.
Mr. Chakravarti,
My lord.
stop short of this. Kindly try to understand. You are, suppose you are in possession of his property also, the entirety of 5 acres, 5 point something acres, which was supposed to be acquired. You have taken possession of that.
Yes.
If you have taken possession of the entirety of that, by what authority can you ask him to refund money for something else? What else? You have got the land, quantum of land, for which you had initiated the acquisition proceedings.
Lordship.
You have, in the process, taken possession of someone else's land also, in addition to his. It is not your case that you have taken lesser land. Second, even if it is your case that you have taken lesser land, what is the option open for you? Option open for you is to take possession of that land which you have already acquired. On that land, he cannot claim title because title has vested in you.
Yes.
Now, so you claim title to that property, you have that property.
It is vested,
you can
no?
take recourse to that. So far as calling upon him to pay money is concerned, by merely correction of the records, can you do that? How? How can you do that? Is it an arithmetical mistake? It is not an arithmetical mistake. You have acquired a particular portion of land. On the basis of acquisition, you have paid the compensation. At the time of taking possession, you have done something else. That is not a mistake in the award. How can that be a mistake in the award? What can be corrected? What can be corrected? A correction can be done if it is a mistake in the award at the time of passing of the award by the competent authority. If the parties have committed a mistake in utilizing a different portion of the land than that which was acquired, then that cannot be attributed to the competent authority for it to correct the award. That cannot be done. Try to understand this.
Yes, my lord.
Please speak to your officers, try to instill sense in them. This is not done. This is not the law.
I have completely followed. But in the last occasion, I also admitted that portion.
No, you are not following because you are re-arguing the same thing over and over again without following. You are doing disservice to section 152 also. You are doing disservice to the interpretation also. Section 152 does not contemplate correction of an order or an award by reason of the some mistake having been committed by the parties.
Yes, my lord.
It is for the court's clerical or arithmetical error.
Yes, my lord. Yes.
Or
of
if the
course.
records reveal something else. The acquisition is for X land. The records show that X land was acquired. Award is paid for X land, but at the time of utilization, taking possession, you take X minus 2 and Y.
My lord.
This is your case.
Absolutely.
So here, how can you correct the award? That is the question.
My lord, I'm on a different pretext, my lord. I am not saying this 152. My lord, although the language.
151, even 151.
151.
What?
If it is-
151 what? 151 you will get what? You will get the money back by correcting the award. How? How?
My lord, for the ends of justice
For
and
ends of justice what? You are in possession of the property. Ends of justice, you sell the property. How can you declaim the property now? The entire process of
there is
acquisition
no
has been
provision
done.
for divesting. My lord, that is
The
not.
entire acquisition has been done.
Yes.
How will you undo the process at the stage of award? You tell me that there is a notification, there is an award.
Absolutely.
There is an acquisition, there is an award. You have acquired the property.
Yes.
Suddenly, because he has made a prayer, at best his prayer will be rejected. But how, under what law will you go and correct everything?
But there are two prayers made by the petitioner. One,
both his prayers are rejected. But because his prayers are rejected, does it conversely mean that you will allow something else on his petition? How?
no, my lord, if my lord sees my lordship, may I just try, my lord? May I just try, my lord?
You are trying absolutely in the wrong direction. I am not being satisfied at all, because you make your submissions in law, something which has legal basis. You have not been able to show any document, any provision, any judgment.
My lord, I am ready with that. My lord.
Show me that. Then
Lordship,
necessarily don't
lordship.
waste time in
No,
making your
my lord,
talks.
not at all, not at all.
Show me the judgments.
Lordship, may I just indicate the provision? First, I place, my lord, the provision 16B, my lord. 16B, may I read it for your lordship, my lord? The competent authority, and the appellate authority, my lord, may exercise powers of the nature referred to in section 151 of the Code of Civil Procedure to the same extent and for the same purpose as such powers are accessible by civil courts. My lord. My lord, 151.
151 is known. Don't read.
Yes.
Yes.
But only, Baba. And but I would like to
Only
152
151
only.
is known to me. Don't read unnecessarily. I have it. I have my books.
Okay. Also 152 are like to
152 is arithmetical clerical. Yes.
For that once. For my satisfaction. Nothing in this code shall be deemed to limit or otherwise affect the inherent powers of the court to make such order as may be necessary for the ends of justice and to prevent abuse of the
What is the ends of justice here? That you should be in possession of extra land and should be in possession. Ask him to pay money. Is that the ends of justice? Were you not also responsible for the mistake? Why did you take in possession a property which was not acquired? For so many years, you acquired a property and you took possession of a different land. Now suddenly, because he has pointed out he was entirely wrong, his petition should be dismissed, has been dismissed rightly. No order can be passed on that. But in so far as your mistake is concerned, how can you ask him to pay money back now? You take the property, you have the property. Nobody is calling upon you to revert the property back to him. But you keep the property. If you say that now I will release the property, get the money back, you have to show me the provision. Under what law can this be done? Till such time that you satisfy the court, you cannot do that.
Lordship, that is what I am trying.
No, not trying. You should. That is the question. Please answer that. Unnecessarily, don't waste time in 151, 152. That is not the provision under which you can do that.
But may I please, my lord, one judgment, my lord? 2011, my lord, 11 SCC, my lord, page 275.
What is citation?
Paragraph 12.
Citation.
Paragraph 12, my lord.
11 SCC 275.
This is on 151. What is the ex debito justitiae? This is
yes.
Justice Ravindran's judgment, well known. show me something on this. You are showing me something.
I would say, Malad, that's why I was trying to place Malad 152.
Please don't unnecessarily, you are not answering the court's query, you are beating about the bush. That is taking a lot of judicial time. You please answer the query of the court. What is the way out by which you can ask him to pay money and you can release the property? Show me your authorities on that. That is the specific question. You cannot take general laws. This is a special act which you will have to follow.
No, that
You have
my answer, that matter I do not have any authority on that. The only authority I have, the under 151, this
Under
can
151, you cannot demolish somebody's house, can you?
No, no.
Ex debito justitiae, I want your house to be demolished. Can this order be passed under section 151?
Absolutely
So
not.
151 is not like that. 151 is an equitable provision which has inherent powers of the court to do justice.
Absolutely.
Now, what is justice here? You have also committed the same mistake which he has committed.
Yes.
Upon both of you committing a joint mistake, you have taken possession of a property which was not to be taken possession of, and you have taken possession of his property also.
Sure.
So you have taken, in fact, more than what was required to be acquired.
Yes.
Now you come to know about this and you ask him to pay money. You please file an affidavit disclosing what is the area now under your occupation. Please file an affidavit disclosing the total area now under your occupation after this acquisition award, so that I can also form an opinion whether the portion which is under his occupation.
But only to that extent, my lord.
Yes, of course.
Yes.
Not only to that extent. If you want to make any further factual assertion, you please make that factual assertion. But then unnecessarily don't expand it too much.
No.
And till such time that it is under consideration, don't coerce him to pay money.
Or, my lord, I will take instruction on that also. But in the alternative, my lord, it is just have come across in my mind, my lord, if my lord wishes to remand back the matter to the appellate authority, my lord, although it has been acquired, but there is no question of, my lord, there is no provision allows me to, my lord, divest the issue, my lord, the land to the person concerned who is actually.
So you come back and tell me, I can then remand it.
Yes.
I will immediately.
I'll take the proper instruction from the client.
If they are agreeing to remand, then I will remand it by one line.
Yes.
Unnecessarily, I will not make observations which will go against him or you.
Absolutely, my lord.
That this needs to be decided.
That will sort out the issue.
Yes, so that both of you can have your points there.
Yes.
Both of you come and say that yes, let it be remanded before the appellate authority. The entire
competent
order
authority, not the appellate authority, but the competent authority.
Let him come and say whatever it is.
It can be competent authority, my lord, because
then you come and make your submission, because that will be a order on consent then.
Yes.
I will take your consent and pass this order.
My lord, I'll come back with an affidavit in that case, my lord.
Yes, when should I keep it?
Huh? But 3 days time, my lord. 3 days time given. In the one.
Yes, two. You are appearing for whom?
I am appearing for petitioner, my lord.
You are appearing, Mr.
My lord, in below section two.
Two.
Not
Then it's not today.
But,
Other side is not there.
can it be taken up on 7th, my lord? Can it be? Because
Yes.
on same heading, my lord.
So next.
My lord, I beg to appear on the petition. Well, this is second round of writ petition, my lord. In earlier writ petition, while it was considered by the Honorable Coordinate Bench, it was the stand of the WBSC DCL that OLE permission, there were some objectors that has been resolved. Last but one page, my lord. But accordingly, I was expecting to get the connection and a pole was erected. Subsequently, my lord, last page, my lord, that has been communicated from the office of the WBSC DCL. Another person has raised an objection. Well, this is going on, my lord. Instead, cut.
The bailiff which was my lord assigned to us, my lord, we attempted thrice, but failed because 3-4 persons he has named also, they opposed us. Then my lord, we proposed very well, give us alternative. Then he showed us one alternative way, saying that the alternative way belongs to him. Then my lord, we deputed our man. When he wanted to my lord, do the work, then somebody came forward. He said, no, this is my land. He said initially that is the government land. But this person now claiming this is his land. And my lord, in the prayer, very fairly made one prayer, let it be referred to my lord, district magistrate
No, no, no.
presides of the issue. That's my lord rightly done.
The petitioner is aggrieved.
Item 17 and 27, these are two connected matters. Now, previously when Justice Kapoor was presiding over the bench, his lordship directed us for a talk of settlement. That is going on. Kindly keeps both the matters after 2 weeks. Because in these repetitions, he has challenged.
Yes.
Yes, Lordship, that will suffice. Item number 27 is, we are also appearing as respondent number.
So when do you want? You tell me, I will record
2
them.
weeks after.
2 weeks.
2 weeks I have to take this.
I tell you, Lordship, there are 50 lakhs.
No, there is a talk of settlement or not. You please convince your friend and make submission, because he wants Passover, he wants 2 weeks. That can't be done. I'm passing it over. You all
Yes,
decide and tell me. Passover. Chalo next.
18. 18 I am for the
18, Lordship, I am for the petitioner. Lordship, this is petitioner has applied for a connection for the submersible pump, Lordship. Lordship, thereafter the WBACTCL authority made inspection and they have stated that the connection could not be effected due to it is techno-economically not feasible. That petitioner has to pay a.
Because we shall have to install 14 number of poles.
Lordship, may I say?
Monetary involvement is more than near about 4 lakhs. And our scheme is, your Lordship knows me, Lord, beyond 2 lakhs we will not. If he agreed to pay entire amount, we will.
Lordship, may I submit? Thereafter, Justice Kapoor directed the ACDCL authority to conduct one joint inspection and to file a report.
That has been done and that was there.
Lordship, Lordship,
Yes.
Lordship, they have filed the report, Lordship. Lordship, kindly sees the regulation once, Lordship.
Where is the regulation?
Lordship.
Tell me what is the name if I have.
Paragraph 8B.
Lordship.
It starts from 8B. Already connection study
Yes.
Lordship, may I read the
distance is 400 meters.
What is it that you want to drive at?
Lordship, the next page, Lordship.
Yes, next page.
Lordship, 4.4.6a. However, the next page, the first paragraph. However, in the following cases, the licensee is required to extend the connection where no techno-commercial feasibility study is required to be conducted at all. Lordship, the point 1, the agglomeration of habitation under a village hamlet where electrification is already completed. Lordship, this is Nolhati. This is under Nolhati. It is already electric, and the report also states that the entire village is electrified, only it is overloaded. That is their report states, Lordship.
No, it is distance from his premises where he sought to.
But in terms of the regulation, you read this regulation.
Lordship.
4.4.6.
Lordship, I only had one copy, Lordship.
Read this regulation.
No.
If the village is electrified, then you cannot say that.
Well, it is not the village. Where the transformer is already existed, the distance is 400 meters.
That is not the norm. You don't say that this distance will
Then
be
Milord,
400
we
meters,
shall
will not give.
Village, but the joint inspection report is there, my lord, it is
Joint
beyond
inspection
capacity.
report does not refer to any regulation in terms of our guideline. Which guideline?
Guideline,
You not have a secret guideline. You show me.
no,
which-
no, not
which
secret
That is
guideline.
their guidelines,
guideline you have.
their office
Then,
order.
my lord,
This is the regulation.
my lord, may I,
Which guideline?
my lord, may I? I
which
shall
regulation?
come up with an affidavit details. Your lordship kindly decide with.
Necessarily, but then you should have indicated what guideline, what regulation. How will you deal with
That,
this?
my lord, report is not indicated. That's good because they are the station manager has prepared a report.
No,
If your lordship is so desire.
ask for a report, he will not give it like this. He will indicate what is.
No, no, my lord, it is there in the regulations, but my lord, the distance is 400 meters.
Has also to be in the regulation only. 400-meter merely because if somebody is ipsit dixit, he says 400-meter, I will not give. That cannot be. You have to show
No,
it from the regulation. The regulation is in
That
place.
is there, but
Show
then
me
you,
that from the regulation, it is beyond distance. I will not touch it. But if the regulation does not say, why will you not give him?
no, no, no. এইটা কোথায় এটা? My lord, 8B, my lord expenses. If after consideration of, if after,
4.6B.
my lord, kindly, 8B. No, no, ওটা ঠিক আছে. 8B. If after
4.4.
No, no, my lord, I am coming 4.4. 8B, after consideration of the detailed report of techno-commercial feasibility study.
That is not applicable to you. Next. That is why I am saying next page. Next page. Yes, read that. That is applicable to you.
Yes. That's my learned friend says in the village there is a electrification, electrified area.
No techno-commercial study is required. That is what he is harping
Then,
at.
my lord,
So the first portion which you are relying on is not applicable to this.
Yes, my lord, your lordships kindly give me 7 days time so that I can, my lord, come up with a composite instruction so that.
Give me that.
Lordship.
Mr. Haldar, learned advocate appearing for the petitioner, submits that in view of
পরে আচ্ছা হ্যাঁ পরে দিচ্ছে বলছি
I am for the WBSC.
I'm for the petitioner, my lord. There is a direction lordship will find 28 January 2006, 26, my lord. The physical inspection along with my lord, after my lord physical inspections, they have installed the electricity connection to my premises.
But this is my report.
Then
I have told them to resolve the issue once and for all.
both
Because
both লিখে নিন জানাদা লিখে নিন both the
Earlier order, my lord, I served upon the private respondent, my lord, he refused. My lord, endorsement.
refuse.
He is raising objection.
You have no problem.
No, we have no problem.
My lord, I am the tenant.
But Milord,
Milord,
I
civil
must
suit is
tell your
pending.
lordship, Milord, my instruction is space. The tenancy agreement has already been over. Suit is pending. The litigation is.
My lord, I filed a suit for declaration of tenancy right, prayed for injunction, run at court below.
I mean, fact.
My lord, in this matter, I am appearing on behalf of the private respondent. I have not able to file my wakalatnama because I don't have copy.
Yes, because you have refused service.
No, they have not received.
Yes, they have refused. How will they receive? It has come back with endorsement refused.
From which address?
From whatever address. Refusal is good service.
I have not.
The address is not important if it is refused.
If I will serve, I will appear, my lord.
You have a copy on it.
Tomorrow-
Refusal is absolutely good service. Whatever address. It was not claimed left, then in that case you could have claimed that it is wrong address. Refuse means you are there, you have said I will not take.
phone number
নাম record করে নিন।
phone number
Take your envelopes, because
Yes,
you have not stitched it, they will get lost. Yes.
I am for the petitioner, my lord. My lord, kindly,
I'm the WBSC
my lord,
detail,
kindly allow me.
A direction was given to file a report.
1 minute, my lord. The affidavit service last occasion I have not filed, my lord, kindly affidavit service. Kindly, my lord, allow me.
No
to file,
exception to the report has been filed.
File one supplementary affidavit.
This is blank.
Blank.
Yes.
Not blank, my lord. There's
Yes, but I can't
It is.
read anything from there.
This is
Nothing can be made out.
anyhow, he has appeared, my lord.
No, other respondents, he is
No,
representing.
there is no private respondent.
Very good.
Okay.
Yes, what is the supplementary?
One supplementary, one documents representation I have made in the year 2014, my lord. At the time of filing deed petition, not available. But after later on, my lord, it was found, and I am annexing this document.
Because a specific point was taken in my report.
My lord, kindly.
My lord, he has.
What is the matter?
Matter, my lord, the petitioner applied for electric connection in the year 2008. After quotation bill, I have deposited an amount of rupees 80,350. But due to pendency of the civil case, they are arrested for the giving connection. Thereafter, after obtaining order of injunction, but I have went to the office for connection. The station manager advised me for filing new for applying the new connection. New connection, quotation bill raised, I have deposited, and connection has been given. But the previous 80,000 not refunded. My lord.
Yes, Mr. Chattopadhyay, why are you not refunding him?
My lord, I have made it clear. Money deposited, we have received it. My lord, 2008 matter. Everything was being done manually. My lord, we have sought for the original they have produced. That is also admitted, my lord. That is no difficulty. Now, my lord, the original that is produced by them has to be, my lord, compared with, my lord, the database of the, my lord, the office.
But you have received money, give him his money back. He is entitled to it.
True, my lord, but we are in search of, my lord. As of today, my lord, I have taken instruction, my lord, day before yesterday, my lord. We are in search of that, my lord. See, kind direction, my lord. Because one thing, my lord, 2008, my lord, he has approached, my lord, after 17 years.
No.
Everything is, my lord, 17 years, my lord. He has experience, my lord, nothing remains.
Sum, please pay it back to him. He is entitled to his money. You cannot.
My lord, I have supported his case. It's not that I will not pay. Only point I have taken, my lord. After 17 years, my lord, no document is available presently, my lord. We have sought for, my lord, the original that was provided, but, my lord, the documents to be compared with the original. These documents.
How long will you take? How long will you take?
কতদিন
How long will you take? You have to give a tentative time, because you will take another 17 years to refund his 80,000.
The matter was filed, my lord, in the month of January.
Give him.
Already 8 months over.
Because it's his money. You are a public authority.
True, my lord. True, my lord. We have not denied.
And he has paid again. Rather, it would have been proper on your part not to claim again and adjust it against the earlier payment.
That prayer was not made. Had it been, my lord, that could have been adjusted.
Very well, now that has been done. Whatever has been done has been done. Since you are in a possession of excess money, refund it to him. How long will you take? You tell me, give a timeline so that I can make directions.
8 weeks, my lord. Can you make it 8 weeks, my lord? Will, my lord, what I am praying, my lord, definitely, my lord, in the my lord report, you have not, my lord, denied his claim. So what I am on today, my lord, kindly give direction as early as possible. My lord, I have already given instruction, my lord, to do it as early as possible. But if you lordship kindly given timeline, my lord, this will be a bit difficult.
But as early as possible, my lord, without saving time, my lord. They will take another one for 12 years or 15 years. I will be suffering.
Very well, I am not disposing this off. I am keeping it pending. You that will be
in the
better.
next monthly, my lord. In the meantime, I am trying my end.
That will help you. Supplementary affidavit filed on behalf of the petitioner is taken on record. You have received a copy of this?
Yes, today, my lord.
A copy of the said Because let them check what is happened, who has given. Next.
My lord, 22, I am for the petitioner, my lord. On the last occasion, the affidavit of service was not filed. My lord, there was a push on the button.
Yes, there was a direction to file a report.
My lord, we will try to file an exception to this report.
Report लिखे नहीं. The report filed on behalf of the WBSCDCL authorities in terms of the order dated February 3, 20.
Here, Milord, 23, 24 numbers of Milord industrial consumers file this writ petition with a prayer to refund their Milord security deposit, what they are asking for. Milord, security deposit in respect of every Milord the connection. Separate.
Petitioner is not there. लिखे नहीं. None appears for the petitioner. No accommodation is prayed for.
My lord, I'm praying for an adjournment for 2 weeks.
Weeks, why?
My lord, the petitioner is currently hospitalized and there is an instruction is needed.
The new electricity connection has not been given while in spite of direction by the district magistrate.
You are for the petitioner?
No, I am for the private respondent. Not
Complete petition.
Petitioner came before your lordship only for restraining the electricity department not to install a new electricity connection in my
time. You are restraining him from taking electricity connection, and now you are seeking time.
My lord, the petitioner is currently hospitalized and there is an instruction is needed.
You want his electricity connection to be installed, and you will not appear.
My lord,
Yes,
there is
Mr.
an
Mukherjee,
instruction. There is an
order has been passed.
There is an order passed by this Honorable Court directing the district magistrate to look into the matter and faster. Where in front of the district magistrate, there were joint inspection which was held, including the BDO, the BLRO, the petitioner and the private respondent, and also the officer of WBSCT for finding an alternative route. We could not, my lord. When the matter came up before this Honorable Court again, my lord, Justice Kapoor directed us to hold an inspection and this report to be filed. We again inspected, my lord, we could not find any alternative route.
The DM has not been able to find out alternative
No,
way.
there is no. There is no, my lord. My lord, we have categorically stated in the report. My lord, may kindly see the report.
No, where is the DM's order?
That is there, my lord. That has been challenged. That has been
DM's
challenged.
order has been challenged by him.
Yes.
If the DM says there is no alternative way out, then he is happy.
There is no alternative way out, and with this order we can grant electricity. My lord,
Through Panchayat Road, he has said. What is the problem?
He doesn't want that.
He is not the Panchayat.
No, he is the petitioner. He doesn't want to.
He is not wanting will not do. If he is not the Panchayat, how can you prevent him from taking electricity? Who are you?
Why not we kindly come to page 42?
Lord, I'm not really familiar with the matter.
Please ask your client to make appropriate arrangements. This cannot be unnecessarily stalled. He wants electricity connection. He will come and take time at your sweet will. It can't be like that.
Not kindly grant.
I'm giving you 1 week's time. Next week, you please take instructions and appear. Learned advocate.
I'm for the petition. I will.
Before he starts, my lord, I'm taking a preliminary point regarding the maintainability.
Why?
Because, my lord, there is an order of the RGRO. Now, my lord, there is a direction to make some payment. If he is at all agreed by that order, my lord, there is a provision that he has to approach before the ombudsman.
Your Lordship, the GRO order was accept the provisional payment of 50% of the outstanding due, which is, your Lordship, is paragraph.
What was this dues for?
Dues is, my lord, he has not paid the amount. There is a billing dispute.
Oh, billing.
Inflated bill was issued, your Lordship.
Yes. So what has RGRO done?
The RTR done, your Lordship, instruction that install a new toad meter, reconnect the service, and accept the provisional payment of 50% of the outstanding dues and cancel the previous disputed bill and regenerate bill. And raise the 0 unit bill for the period of disconnection.
Everything will be clear if you let see page 31.
31 is your letter. Where is the GRO's order?
RTR order is at page 27.
So all the bills were to be cancelled. All bills raised in respect of service connection such and such for consumption period 4/2/2024 to 17/1/2025. And you have regenerated the bills.
I got it.
There was a direction on you to cancel.
Absolutely, my lord. But kindly see, my lord. Kindly turn to, but your Lordship is on at page
28.
28. The my lord licenses. Now kindly see that he has to first 50% ordering portion. The petitioner shall make a provisional payment of rupees 50% of the outstanding dues.
Where are you reading?
At page 28, order, second paragraph.
Yes, he has not done that.
That he has not done. My instruction I have handed over to your Lordship, my lord. Am I right? That's why he wrote a letter through the lawyer, which you have clarified at page 31.
What is the date of this order?
But the date of the order is at page, the Lordship will find 27 February.
No.
8/9/25.
So you want implementation of that order only?
Your Lordship, I will implement that, but they refuse, Lordship.
You are supposed to pay that 50%. You pay 50%. They will do all the balance. You please come as page 27. Understand what you are supposed to get.
27.
Yes. You want implementation of this order. This is your prayer. You first see your prayer. First see your prayer and keep page 27 open.
Yes,
Please
Your
see,
Lordship.
yes, please see.
That is disposition of
Please see prayer A.
prayer A.
Implementation the order.
You want implementation of this order, right?
Yes, yes.
Now come to page 27. This is the order.
Yes.
Now see the first direction.
The petitioner shall make
Accordingly, licensee is direct to install a new TOD meter. Has the licensee done that or not? New TOD meter has been installed.
No, no, no.
Thereafter come next. You will do that.
I will, but unless he pay the amount.
No. That was not that was not premised upon his payment. You will do that immediately. Please see next. Petitioner shall make provisional payment of 50% of outstanding dues in terms of clause such and such within 1 month.
Yes.
So you have to pay 50% of the outstanding dues. But 50% of outstanding dues, how? I don't understand. If he has cancelled the bills, 50% of what will he pay?
But what happened, Marat? There is a huge due. Well, that's why I'm requesting your lordship kindly see entire thing will be clarified at page 31.
Page 31.
Now, Marat, may I just read? One intimation received from your deputed advocate mentioning a series of false allegations not required. Now, no FIR lodged against your agricultural connection, void connection number such and such. One FIR lodged against you as a non-consumer on 27/1/2017, void FIR number such and such dated 27/1/17 for direct hooking as different agricultural premises where no legal connection exists at the time and necessary provisional order served with a reference void memo number 27/1/2017 with a direction to submit a pilferage fine amount of rupees 3,92,852. Thereafter, you paid for a hearing against the provisional order, and after completion of hearing, one final order issued with a direction of submit pilferage bill of rupees 248,484 only. And after receiving the order, you have submitted half of the final pilferage bill, that is 124,242, and moved to Appellate Authority Bardhaman for further hearing. For revision of final bill, accordingly, necessary hearing conducted by the Appellate Authority and as per direction revised. Final order issued void dated 20th May 2017, where final pilferage bill reduced to 184,329. Therefore, a sum of pilferage bill rupees 60,087 stands pending at the time, which is yet to be cleared from your end. But you claim that you have paid total final bill against the pilferage case number such and such. You have paid a sum of rupees 1,90,000 on 1/2/24 against outstanding rupees 372,695 and next bill generated on 4/3/24 for period of 29/1/24 to 29/2/24 of rupees 3,05,666, which includes outstanding amount 182,717, energy 270.28 fixed charges. Then it has clarified. Then kindly see, therefore, you move to RGRO regarding billing dispute and one hearing conducted regarding the said matter on 13/3/25 and final order issued by the RGRO as follows. Then order has been quoted. As you have not cleared 50% outstanding amount of rupees 361,297, which was due when you have moved before to RGRO, then is on March 25, no further steps like reconnection of your agricultural connection with replacement of defective meter and bill generation was not performed by this end. Now, what he is asking before your lordship, he is asking for implementation of that order. Therefore, he has to pay the 50%. He has not challenged the order of the RGRO.
What will be the use, Mr. Mukherjee? He pays 50% and thereafter you
But
find...
that will be adjusted. What he is paying before your lordship. But today he has challenged.
But if the RGRO has cancelled
but
all
then,
the bills,
then according to your lordship, RGRO order is bad, then he has to challenge.
He has challenged it unnecessarily. I will not send him. This does not make sense. You recalculate the bill, send him, he will pay immediately. If he doesn't pay, disconnect. Yes, what is the problem? He will pay, then you
But
will again
kindly-
refund. What
kindly
is the use
visualize.
of this?
He cannot
this,
take.
this direction should not have been passed by the RGRO in the first place, because if he has entertained the complaint, he should have entertained it and passed orders. If he wanted 50% payment at the threshold, he should have directed him to pay prior to taking up the complaint for final orders. If once he has passed final orders, this payment of
This
50.
is the draft order. But kindly visualize one thing.
Mr. Mukherjee, this is an exercise which is redundant. He should have done it at the threshold, at the time of receiving of the complaint, because he has gone by regulation 3.5. 3.5 is that when you move GRO, like pre-deposit.
Pre-deposit,
Yes.
condition.
Yes. So this was something which he should have done at the, this now makes the entire order absolutely topsy-turvy. First portion he says pay 50%, then he says all bills cancelled. Now, what for he will pay then?
May I see one thing? But kindly visualize one thing. But admittedly, my lord, he went regarding the pilferage, there is the outstanding bills. Now what?
Mr. Mukherjee, records will be straight this way. Instead of him paying 50%, you raising bill, again refunding if he has paid, you raise all these bills stand cancelled by the order of the GRO itself. If all these bills stand cancelled, you raise a bill which according to you is now payable by him. Instead of let him pay one amount, that amount he will pay, you restore supply.
But then what will happen? May I just say? In the body of the writ petition, he has never challenged the any discrepancy what is fallen from your lordship by the RGR. What he is praying for? Implementation of that order.
That is, we are becoming technical. He is a consumer. He is a consumer. He has. He has also made a payment to accept a provisional sum of rupees 91,099.
91 is defined. That has already been meant. That is also wrong, because regarding the pilferage, what we are asking, let him pay the pilferage bill.
That is not the condition of the RGRO's order. That was not there.
Total dues. If your lordship see, if your lordship kindly see once, my lord, his amount will come 1,90,000.
Why?
Because why, my lord? I'm saying, your lordship, because if your lordship consider two things. One is, my lord, that my lord, what is the previous due? Then previous due has to be, my lord,
where does this figure of 361,297 comes from?
372,695. This is the total outstanding till 2024. Now, if your lordship say we have to issue fresh bill, we will issue fresh bill. Definitely, pursuant to your lordship direction, then he have to pay. Again, he will go to RGRO. Again, same thing.
Yes.
Because he is not the innocent.
Let him know.
If your lordship, the competent authority, raise a fresh bill, then my client will be
paying. No,
but according to the, he cannot pay 3,70,000.
3,72,000. This bill is in respect of assessment dues. He is saying assessment order you had not challenged. Final order of assessment.
No, your lordship.
Then if final order of assessment you have not challenged, then that is a problem. If there is unauthorized use of electricity and you have not challenged it, you have taken instructions from your client, because that becomes difficult. Then final order of assessment passed.
No,
you have not got
on
it.
that basis, I don't have the instructions.
Take instructions on that, because once I pass orders, it will be difficult for you. Try to understand two things. You will take instruction. One is final order of assessment. There are dues, unauthorized consumption.
That he has challenged.
Pilferage of electricity.
That he has challenged.
Where?
Kindly see once.
So what happened to the challenge?
My challenge, my lord, ultimately that has been disposed of. If you lordship see, once my lord, my letter.
Very well. If he has challenged and disposed of, then that dues remains.
Yes. Kindly see my paragraph 1. It has clarified.
But your lordship, the half of the money was given. The half of the money was given. So
the balance half only they will take. They will not take the full of that. The balance half comes to 3,760 something. What is the provisional order of assessment? Final order of assessment balance?
Provisional order of assessment was 3,92,852. Thereafter, final is 248,484.
You do this, Mr. Mukherjee. Instead of asking him for making payment of 50% of the disputed dues also.
I will raise a fresh bill.
You raise a fresh bill only in respect of the assessment dues, because the other dues you are required to calculate.
No, that we have already calculated. Kindly see paragraph 3. We have stated. You have kindly see. You have paid a sum of 1,90,000 on 1/2/24 against outstanding of 370 to 695 and next bill generated on 4/3/25 for period of such and such. That includes outstanding amount. We have calculated. If your lordship wants, my lord, I will place everything. But if he wants to challenge the same, he has to go before the either before the RGRO or before.
That was challenged before the RGRO. You are reading only paragraph 2.
Yes, kindly say.
Thereafter, that was challenged before the RGRO.
RGRO.
So therefore, this 361,297 is not the final figure. It can't be the final figure. It will include the provisional assessment,
Absolutely.
final assessment dues. But so far as your billing dues, consumption dues are concerned for the period 29/1/2024 to 29/2/2024,
But
that has to be recast.
After adjustment, it comes to 361,297. Paragraph.
Where is that? Doesn't show anything.
Paragraph 4.
Paragraph 4 doesn't show. It is only the
But
conclusion.
I will issue the bill. I will definitely issue the bill.
Issue a bill in the meantime, take instructions, because if you pay, you will get reconnection.
Yes, sir.
And since he has come over here, say, resolve
If
it.
he has not challenged, but may I? Your lordship knows when I'm appearing for the authority, I have to. But if he has not challenged the order, number whatever dues now, number either he has to pay.
You take instructions on the provisional bill. Why you are not willing to pay this? Take instructions that this, tell your client that these dues include not only the billing dues, it also includes the assessment dues.
Total dues I will pay.
This 361,297 includes all the dues.
All the
Yes.
All dues.
It includes the consumption. There are two kinds of dues. One was for pilferage, for abstracting electricity illegally. That is one portion of the dues. One dues is you have used, bills have come, you have not paid, meter dues. Both these dues together come to 361,297. Take instructions on this then. Learn '26 কল করে দিন কি আছে ওইটা আগেরটা দিয়ে দিন না
আগেরটা
10th February 2026, my lord, there is direction for to file report, my lord. And till date, no report has been.
Report to him right now.
where you have filed report.
No, I have not filed. With direction, I have taken 3-4 days for affidavit, but copy I have received. I am handing over a copy to my landlord.
No, then what direction will I pass? You hand over a copy, you file report, I'll take it.
Great.
Item number 7. It is ready to file after a week.
File it, I will take it.
Yes.
Let the original side be called. What do you want to mention? Give it, give your slips. Yes.
Lord, upon being instructed by the learned master regarding you, my lord's intervention is required before I file this proposed application. My lord, I intend to file an application under section 307 subsection 2 subrule 2 of the Indian Succession Act, in which a letters of administration has already been granted to the executor who happens to be the sole beneficiary to the estate of the deceased. Well, thereafter, the executor and the administrator has also filed his accounts and inventory in the proceedings and also discharged with the administrative bond which was furnished at the time of obtaining the letters of administration. Now, my lord, at this current scenario, my lord, he wants to take a loan by mortgaging that property, and under section 307 subsection 2 subrule 2 it says,
yes.
Under section 307 subsection 2 subrule 2 it says, my lord,
সব দেখে পাঠক আর কিছু দেখাবে? তুমি মামলা করবে এখন। আমাদের পরপর জেনে Lord,
yes.
5 judgments have been cited by my seniors, Lord, on the other side. Lord, I'll just very quickly, Lord, try to distinguish those judgments. Lord, kindly take the first one, 2014 4 CHN Calcutta 36263, Chanchal Bhattacharjee.
2014.
2014 4 CHN Calcutta 263, Chanchal Bhattacharjee.
Yes.
Lord, the issue in that matter was, in the revisional application, an order was passed without notifying the caveator. An application for recalling was filed that was considered and allowed. Like in the present revisional application, we lodged a caveat. If your lordships have passed an order without notifying us, or without they notifying us, then Lord, this would have applied. But in the facts of the present case, this cannot be made applicable. But kindly take para 3 once, para 3 of the application, or para 1, Sri such and such advocate appear for the petition in CO 1146 of 2013. This is 1146 of 2013. Para 2, Sri Bishas also appears for the petition.
It was before the same court, so it was recalled.
A recalling application was filed. The question whether they are to file an appeal or a revision, whether the order is revisable or appealable, perhaps this doesn't throw any light on that. Right? But yes, this nothing. And moreover, here if my lord sees in para 4, the application out of which the revision has arisen, that was an order under order 13 rule 7. So that was a revisable order. So revision was rightly filed. And then this issue came up whether, no, I am not, even for a second, we have argued on the merit of the matter. We are saying that it is an appealable order, it has to go to the appropriate authority, which is not taking up the.
How will a petition saying that you recall the order because you have not heard me become an appealable order merely because it has
Milord,
extended or not
Milord,
extended?
as I have shown your lordships on day one, the ultimate order that would have been passed is by recalling or revoking the interim order, injunction.
Vacation of injunction may be the ultimate result.
Yes.
But that does not mean
That was the prayer also. That was the prayer also.
To be, because he seeks recalling of the order. He seeks recalling of the order. But does that mean that it becomes an order with jurisdiction? Because the judgments which he has shown show
Milord,
that
it is
if you have heard a matter which, wherein caveat has been lodged, and if you have heard without honoring the caveat, then in that case it is an order passed without jurisdiction.
Milord, I am so grateful to your lordships. Perhaps they are referring to Gayatri Chetna judgment that they are referring to. Of the division bench, which we also relied.
There is an earlier judgment also of the Honorable Division Bench.
Yes, 2025 one High Court cases 473.
Which says that it is without jurisdiction.
Milord, Gayatri Chetna Foundation, perhaps.
Gayatri Chetna is subsequent.
Oh, we will deal with that. We'll deal with that. But kindly take Gayatri Chetna once.
Yes.
25
Yes.
Kindly come to para 37. Perhaps that was not placed before your lordships.
Yes.
In view of our observation, since we are of the opinion that the learned district judge in charge exercise jurisdiction not vested in him by law in granting an ad interim order without directing prior service of notice on the caveator, the entire finding in the impugned order are otherwise vitiated by lack of jurisdiction. Now, this was also rendered in an appeal.
Maybe.
In an appeal.
But that ipso facto does not say doesn't mean that the revision is not entertainable.
Not that the Meena Begum says, 2023, which I have shown, Justice Bhattacharya referred that in the first judgment that I have cited. Supreme Court says if there is a provision of appeal in the CPC, the 227 court will not allow 220 exercise its jurisdiction if there is a provision of appeal. Now, kindly considers there is a difference between inherent lack of jurisdiction and then jurisdiction which is erroneously exercised.
No. This is.
But why this is?
There is a difference between jurisdiction being erroneously exercised and inherent lack of jurisdiction. There is also.
It is not a case of inherent lack of jurisdiction.
There is also a difference between lack of jurisdiction and erroneous exercise of jurisdiction. I am consciously dropping the word inherent.
Absolutely.
It may not be inherent, but still there is lack of jurisdiction. For example, if in this case, the person has the court has jurisdiction over the subject matter, but the court will have jurisdiction to, for example, say, let us put it very simple, say limitation. The court has jurisdiction over the subject matter, but it appears from the case record still that the case itself is barred by limitation. Will the court have jurisdiction to receive it? Now that has been answered again by, there are two judgments. One which I recall is of a constitution bench saying that it should be challenged in appeal. There are separate two constitution bench judgments saying no. Those are all orders which can be challenged in revision because those are errors which affect the jurisdiction. So it is a jurisdictional issue. It can be answered in revision also.
Lord, if the court entertains a petition which is otherwise, as has fallen from your lordship's lord, could not have been entertained, but there is a difference between filing of a proceeding and entertaining of a proceeding. But
the question of jurisdiction will only be taken up by the court when it entertains.
When it entertains.
Filing is the
yes.
is the
Filing,
ministerial critical job which the court will not have time to apply.
Like
court will receive the plaint only when it applies its mind to it.
Yes. So court receives a proceeding, like Lord kindly considers the MSMED Act, MSMED Council's award. If you challenged that award under 34, the precondition under section 19 is you have to make a pre-deposit. Now the question may come whether the court can entertain without a pre-deposit. Now, if the court entertains without a pre-deposit and passes a wrong order, that they are saying that it is an order passed without jurisdiction because the court lacked jurisdiction to entertain. But even in that case also, Even in that case also, since there is a provision of appeal provided in the code itself, code itself, and considering Meena Begum, which has been considered by Justice Hiranmoy Bhattacharya in his lordship's judgment, Lord, the proper remedy would be to prefer an appeal. We are here before your lordship on 7 days. We are arguing on the point whether it is appealable or revisable.
Not 7 days. This is
Whatever, not 4 days, 5 days, 3 days, whatever it is. But the point is,
we are going on hearing.
no, the point is that the litigant could have availed the remedy available.
Because of your absence.
Could have availed the remedy which is available to him under the statute. My lord, here in Gayatri Chetna, what the Honorable Division Bench just said, that the court lacked jurisdiction while passing an interim order because there was a caveat and no notice was served. Even that order was also challenged, my lord, in a appropriate appeal, not in a civil division. So, my lord, when there is a remedy available in the statute, my lord, the revisional court should be, my lord, loath in interfering. That is what we are saying.
Very well.
That is the check, my lord, that your lordship, my lord, will consider before, my lord, exercising jurisdiction. Lord, kindly take the next one there. Lord, kindly take, my lord, this. This is Sukumar Roy versus Pratul Kumar Roy. Lord, 1-page judgment from Onupatra, I believe. My lord, this one.
Yes,
90 CW.
90 CW.
90 CW, yes. Bandike lega আছে।
নেমে গেছে সে। জলদি আসছে।
Yes.
Lord, kindly take this 90 CW and 288. Lord, this was also rendered in an appeal. Although
Division, not an appeal.
it was, Lord, kindly see at the top.
Top will not do. See paragraph 1, first line.
Lord, it was an FMAT, first mentioned as appeal. Lord, it may have been a wrong recording.
That FMAT
It
may
is
be
a
wrong.
division bench. Lord, it was,
FMAT may also be wrong.
Lord, it was considered by a division bench.
Yes, yes. Civil
Lord,
revisions
at
were
that point,
considered by
at
division
that
benches
point,
also.
it was CR. Civil division cannot be recorded as an FMAT.
Division bench only.
Division bench, at that point of time, as per my knowledge, it used to be recorded civil rules, not as FMAT, CR. FMAT is a different connotation altogether. It was also rendered on an appeal.
Very well.
But the court has recorded revisional
Court
application.
says revisional application. I have to go by whatever the court says. I will not go by the number and your corrections. I can't take that.
Lord, kindly consider
It
it
is revisional application.
before a
I'll have to
division
say.
bench,
Before a division
and
bench,
FMAT was considered.
Before a division bench,
Yes, at that point of
revisional
time,
applications were maintainable,
were being considered.
and there is a presumption of recording, presumption of correctness of the recordings of the orders.
Absolutely, Lord.
Your correction, I will not take over.
No,
the
Lord, I am
recording
not
of the
on that.
division
I am
bench.
not on that. What I felt that it was an FMAT and appeal was considered.
You may have felt it, but my feeling and your feeling will not do because the
it is recorded in the order.
Court has the revisional application is also recorded in the order. The very first line says so.
First line
It's
and
not
no,
that
no,
something
no.
has not been
First line and
recorded.
last line and middle line also.
The last line also says revisional application accordingly disposed of. So it is unlikely that the court will commit two mistakes in the same
Lord,
order.
kindly seize me, Lord.
If FMAT is written, I will disregard the revisional applications mentioned twice. That is
Lord, it was not argued on the point of.
that is a point which you can take, but
Yes.
don't take this point of
No, but
FMAT.
what I felt that it was an appeal, but even then this issue was not considered.
Very
This issue was not considered. Of course. Lord, 2005-13 Supreme Court cases 777 and 1980 supplementary SCC 420.
2000.
420, two judgments. Greenless Bank and Kapra Mazdur Foundation.
Just a minute. 2000.
Lord, 2005-13 SCC 777
513, yes.
and 1980 supplementary SCC 420.
1980 supplementary. Yes, 1980 supplement.
Lord, these two judgments are rendered under the Industrial Disputes Act, completely unrelated to the facts. Lord, the issue that your lordship is deciding today, completely unrelated to the issue. The point that we are urging was not at all involved in this. Not in my humble understanding, this doesn't apply to the case. I will not waste your lordship's time anymore. Yes, they are saying that it's a question of procedural review. The court could have, but their application itself says they prayed for vacating of the order. Their application itself says they prayed for vacating of the order. Their prayer was that you vacate the interim order. It was not a case that they said you made an error, please correct the error. There was no provision for, and in the second judgment 1980, the court records there was no provision for recalling an order. So that is why it was invoked. Kindly take that 1981. Just take note the facts in the first page recorded. Industrial dispute between the management and the appellant bank and its employees were referred to the Central Government Industrial Tribunal under Section 10 of the Industrial Disputes Act. The date of hearing of the reference was adjourned time to time. Ultimately, tribunal refused to grant any further adjournment and made an ex parte award against the employee. An application was thereafter made to the tribunal, setting aside the ex parte award on the ground that the General Secretary of the Association representing the employee was prevented by sufficient cause from appearing before the tribunal on the date fixed by it for hearing. The tribunal by its order set aside the award on being dissatisfied that there was sufficient cause shown within the meaning of Order 9 Rule 13. The High Court declined to interfere with the order of the tribunal, dismissing the management appeal. Supreme Court. The Supreme Court says tribunal body should be considered to be endowed with such ancillary and incidental power as are necessary to discharge its function effectively for the purpose of doing justice between the parties. Although there is no express provision in the Act or the rules framed thereunder giving the tribunal jurisdiction to set aside an ex parte award, the tribunal should be considered to be invested with the incidental ancillary power. Here there is a specific provision on the statute and they applied under that. The prayer was very specific that you vacate the interim order and for non-service of notice. এটা কোনটা? এটা তো বললি না তখন? Yes. 2011 6 SCC 321.
Yes. Paragraph 49 पर rely करो.
They relied on paragraph 49. Kindly come to that part. Here also like the same, that they lodged a caveat in the High Court. In the appeal, they were not heard. They went up to SLP in Supreme Court. Like the other judgment that they have shown in the civil revisional application, caveat was lodged and recalling was prayed. This also the issue, whether the order is appealable or revisable, that is not the subject matter of this judgment. But we are not arguing on the point whether notice ought to have been served, not served. On merits, we are not arguing anything at this stage. We are only on the point that this order is appealable.
Merits also because
no, my lord, kindly decides on the maintainability.
Why piecemeal?
Decides on the maintainability.
No.
We have argued on the maintainability.
I want you to argue on merits also.
No,
Your
then
argument,
that
you cannot
would be-
take the court for a ride. That will be
But-
done after. If I find that it is not maintainable, it's always open to me to dismiss it on maintainability ground, even after hearing on merits. But ultimately, if I find it is maintainable, I will again bring it in the list. Again, I have heard him. You also finished. I'll close it. Finish it on merits also. And that I had indicated it to Mr. Mukherjee also.
We have completed merits.
Finish it off so that piecemeal it won't. If I find it is not maintainable, it will go as not maintainable.
But I thought that
No, no, no,
your
it's
lordship
question
may-
of thinking.
I had indicated to Mr. Mukherjee on that day that please complete it because it will be on one go. Instead of having it piecemeal, we'll have it on one go. If I find it is
Lord, if the
maintainable.
Lord, if the revisional application your lordship ultimately holds it's not maintainable,
Not maintainable.
then Lord, this submissions, Lord, would be
So
Lord,
what will happen? For 15 more minutes of submission, what will happen? Conclude it. And if I find it is maintainable, then in that case, I will fix one more day, hear you again on the same.
That's what he wants.
What is the use?
That's what I want. That is not the issue.
No, you
But
finish
we
the
have
matter.
taken a point of maintainability at the beginning.
Well, so
Mr.
there is
Chaudhary was
no-
answering that.
If maintainability point is taken,
Mr.
merit
Chaudhary
cannot be
was
argued
answering
at
that point. Lord. Mr. Chaudhary was answering the point of maintainability.
No, no.
all. Finish it.
He has, I have argued everything.
I asked
He's
him to
also argued everything.
I asked him to finish it.
You know, first day your lordship will recall he's argued on merits. He has got nothing more to argue.
No, he has not argued on merits, but I indicated it to Mr. Mukherjee that I am finishing.
No, no,
it
my lord,
with-
even before that, I was in reply. On the first day when he started, he's argued everything. If he doesn't want to, then he doesn't want to. He's got nothing to say. What can he say? There was a caveat he's not served.
Yes.
What I have, what I don't have, my land.
You just
I don't
argue.
have nothing.
And I keep telling you, my sole purpose of coming and sitting here is to ensure that you finish.
Oh, that may be you may have many ideas to come to a court that is immaterial. But kindly take this judgment, Lord, which has been referred 1994 1 Guwahati Law Reports 259.
Yes.
Para 1920 they have relied on.
Yes.
To sum up, that where the court tribunal passed an order without any jurisdiction and violate the basic fundamental principle, kindly consider we have also relied on Andhra Pradesh High Court single bench judgment. That was considered in this case. Single bench. That was also a single bench judgment. This is also a single bench judgment of Guwahati High Court. Now, para 20, Guwahati High Court considers the Andhra Pradesh High Court's judgment. Now, kindly see what has been said.
Para 20.
Para 20.
Yes.
Next, it is argued by Mr. Sharma that even if an ad interim injunction is passed without giving notice to the caveator, it is not without jurisdiction and is operative till set aside. In this connection, he has referred to a decision of the learned single judge recorded in Reserve Bank of India versus so 81 Andhra Pradesh, which it has been held that ad interim order passed by the court without giving any notice to the caveator is not without jurisdiction and is operative till it is set aside. With due respect to the learned single judge, I am unable to agree because in such situation, it would be a case of passing order without jurisdiction and therefore would be invalid. There are no further reasons assigned why he is referring to a judgment of equal strength. Not whether it is appealable, whether it could be appealed against, those are not the consideration here. According to him, it is not valid. According to him, it is not valid.
No independent reasons assigned. Yes.
No independent reasons assigned. Now, my lord, kindly take the judgment that we have given your lordship on day one. Kindly I will take
Same
that
Gayatri
once.
Chetna you had given.
Lord,
Gayatri Chetna and
apart from Gayatri Chetna, Lord, Justice Hiroma Bhattacharya's judgment, JM Financial.
JM Financial. Yes. JM Financial.
My lord, I have referred paragraph 17, 18, 19, 20. 17, the issue that was not formulated by Justice Bhattacharya. Now the question arises whether an order of injunction passed on an application filed under 151 is appellable one. So on that
Here,
issue,
Mr. Chakravarti, here the question was an order of injunction itself was challenged merely because it was not an order under Order 39 Rule 1 and 2 and was one under 151. Therefore, the question arose as to whether that can be appealable or that can be revisable.
here also the order of injunction has been extended by the order impugned. That is under challenge before your lordships. My lord, the impugned order has two aspects. One is refusal to vacate the interim order and the learned judge has consciously extended the interim order.
Yes, extension of interim order is not because of any independent or any separate application of mind. It is just because of refusal to recall the order which he sought.
Completely bowed down
Not
to him.
something that he has assessed the situation again, prima facie case, balance of convenience, inconvenience, and reimposed the order of injunction. The extension is otherwise a routine injunction. It would have followed, but in between, the decision as regards whether I have to recall or not has been taken. You take it that way.
In between, he has considered whether
Now,
the
if the look at it this way, Mr. Chakraborty, just for you to answer it, if he had recalled the order, then in that case, what would have been the effect? You would have challenged it by way of an appeal, or you would have challenged it by way of a revision.
by way of an appeal.
Recalling was not assailable in revision that way.
Lord, it was an application for vacating. My interim order would have been vacated by the court. Then also appeal. Even if it was recalled, then also appeal. The effect is I lose the injunction. Lord, kindly do not go by the nomenclature or what is being said by us. What is the ultimate relief? The ultimate relief is I got an injunction. He wants to undo that.
It is not only the ultimate relief, Mr. Chakraborty. It is an appeal under the code. Under Order 43, Rule 1, the order which is assailable is an order passed on an application under Order 39, Rules 1 and 2. Now, if the order is passed on an application for recall, how would you bring it within the ambit of Order 39, Rule 1 and 2?
Order 39, Rule 4? Order 39, Rule 4?
First provision. If it is an application under Order 39, Rule 4.
Yes. Kindly come to order for 39, Rule 4, first provision. Of course, 43 তে যাবে। R also talks about 4.
Yes.
Then kindly read 4 with us, Lord, once. Any order of injunction may be discharged, varied, or set aside. Lord, kindly pause here for a moment. Discharge, varied, or set aside. Or if it is recalled, then the order will be discharged. If it is recalled or set aside, then it will be discharged, the order of injunction, by the court on application made thereto by any party dissatisfied with such order, provided that if an application for temporary injunction or in any affidavit
by the court. Recalling will amount to setting aside.
Kindly see the grounds. Not only set aside, discharge, varied.
So varied he is not asked for. It will fall under the
discharge.
set aside.
Discharge.
Even non-service of notice.
Kindly see, provided that if an application for temporary injunction or in any affidavit supporting such application, a party has knowingly made a false or misleading statement in relation to material particulars, and the injunction was granted without notice to the party.
These are dual things.
Dual.
Injunction granted without notice is not the ground. It is to be read along with party knowingly has done and without notice. Yes, and is there. So it is not only without notice. So party has done knowingly, so that it is not their charge that knowingly you have misled the court.
No, Lord, there are two aspects. There are two aspects. These are
may not help.
Subject to correction. This is disjunctive. This is disjunctive. Kindly read it with me. If not, kindly consider, provided if an application for temporary injunction is any affidavit supporting application, a party has knowingly made a false or misleading statement in relation to material particulars, and suppose if I made a false statement and the injunction was granted without giving notice to the opposite party, the court shall vacate the injunction unless reasons to be recorded if considers that it is necessary to do in the interest of justice. So without notice, there is and. So suppose if an order is passed without notice, it is not always have to be subject to correction. Your allegation is that the order was passed without notice. Despite lodging a case.
Only without notice, then in that case, you will not fall in the proviso. You may fall in the first limb of Order 39, Rule 4 without the proviso, but you cannot bring it within the proviso. Proviso is for a different thing altogether.
Lord, proviso qualifies the section. Proviso is
an exception to this.
Yes, exception to the section, but it ultimately qualifies the section.
It can be done.
Yes.
You rather can say that you fall within the main limb of
Lord,
the
what is the allegation against me? that I have got the injunction without serving notice upon them.
Yes, but that is not the proviso. You are he.
The main section says if the order is discharged.
Chakravarti, I am speaking in your favor,
Yes.
not for the proviso, but for the main
But for the main section.
You want me to hold that the proviso in your favor? I can't hold that because
But
I'm not reading it that way.
If the main section,
You have to come.
if the main section says that if you discharge, pray for discharge or set aside, if the order is
That
ultimately
taken,
yes,
acted, so
taken.
But
So
you
if
want me to hold that the proviso also supports, I am not taking
Lord,
that.
now kindly take their
That.
application. Kindly take their application now. Kindly see what they have prayed for.
Yes.
Seize their application once.
Yes.
Mr. Mukherjee has praised the application, Lord, in extenso. Kindly take page, Lord, 97.
Page 97. Yes. Yes, page 97. Yes, you had placed it.
Recall, vacate the interim order passed so and so in violation of the statutory mandate. So you are in effect asking the court to vacate or set aside the interim order.
Whatever may be the mode, if the ultimate prayer is for vacating, it is an order under Order 39 Rule 4. Because the court can vacate interim order only under Order 39 Rule 4.
Kali considers if this application was allowed. Could we have come before your lordships? We had to go up in appeal. Because that would have been an order where the injunction is vacated, set aside. They may have prayed for recall on one of the grounds, but the ultimate relief or the ultimate order that would have been passed was vacating the interim order which has been passed. Well, rightly, wrongly, good, bad, indifferent, and interim order has been passed. Well, they are saying that the court had acted in excess or court lacked jurisdiction to pass the order without putting them on notice. Now that's it. That is their case, main case, that the court did not have the jurisdiction to entertain my application for injunction without putting them on notice. It is never a case of inherent lack of jurisdiction. They are making out a case of lack of jurisdiction. But I say that's also a ground of appeal because the order is appealable. Kindly take the impugned order, what has been done by the court. Just for a second, Lord, kindly take.
এই পাশের কোর্টে যেত এখানে রেকর্ডটা এতদিনে চলে আসতো কেভিএটটাও জজ সাহেবের হাতে থাকতো এই তো
Yes.
Lord, Lord, kindly, I'll place the order impugned. Kindly take note the ordering portion first. Just the ordering portion first.
Yes.
The petition dated so and so of the defendant, number 1 of the suit is hereby rejected on contest. Then the effect of initial order of injunction is hereby extended till the next date. The effect of the order of injunction is extended. The injunction order, which was passed by the court, so the order not only rejects his application, but also extends the order. Even if the extension is challenged, then also it is available. It has to go to the appellate court. Lord, kindly sees the learned judge has given reasons. I would say it's a well-reasoned order. Lord, 227 court may not interfere in this, especially when the order is appealable. The order is, they are aggrieved with the reasons assigned by the court. But there's a remedy available to them. They should approach the appropriate court, which can exercise its jurisdiction to entertain the appeal and to look into the veracity of the order. But today we are faced with a situation when the application itself prayed for setting aside or vacating. And the order has refused to vacate the interim order. So your lordships may not interfere in this. And Justice Bhattacharya's order, which I have relied on before your lordships, that specifically records that whatever be the nomenclature, if an injunction is passed then it has to be an appealable order. Now the trial court has also extended the interim order. Now that extension can only be challenged before an appellate court. So I'm not considering this. And kindly just take Meena Begum once it has been referred by Justice Bhattacharya in para 23 of his lordship's judgment. Just have a look at para 24.
Yes.
Para 23 kindly takes. Now the question arises whether availability of remedy by way of appeal bars the exercise of supervisory jurisdiction by the High Court. Tuticorin Education Society and Meena Begum was referred and considered. And para 27, the answer, this court has already held that the order impugned is appealable under Order 43 Rule 1R in view of Section 13 of the Commercial Code Act. In light of the settled position, court is not inclined to entertain the revisional application. Para 23, 24. Kindly take para 24. The Honorable Supreme Court in so-and-so made a distinction between one, cases where alternative remedy is available before the civil court in terms of the provisions of Civil Procedure Code, cases where such remedy is available under the special enactments and statutory rules and fora provided therein happen to be quasi-judicial authorities and tribunals. It was held therein that in cases which may involve civil disputes and other proceedings before civil courts, the availability of an appellate remedy in terms of the provisions of the code may have to be construed a near total bar. It was further held that the High Court ought not to have entertained the revision under 227, especially in a case where specific remedy is provided under the Code of Civil Procedure. Then the para 12 has been quoted. I'm not traveling, your lordships. Then Amina Begum, the Honorable Supreme Court held that when there is an express provision in the Code of Civil Procedure under which appeal is maintainable, a revision cannot be filed by passing appellate remedy. In Pepsi,
Why are you not approaching
Yes.
the appellate forum? What is your problem?
Yes.
Approaching the appellate forum because, in a sense, it is indeed you have prayed for setting aside or
Recalling. Recalling of the order
Found to set
without
aside-
jurisdiction. Without jurisdiction.
That is a
Now,
good
Maharashtra
thing.
consider 13.4.
How will you get around the bar of the Honorable Supreme Court's observation that it is near a total bar?
Yeah, yes.
Only said-
That was considered by my Lord Justice Bhattacharya. My Lord Kali considered. Today, Kali turned the appeal. Expected order of administrative injunction when vacated. Two things. One is there is a statement, misleading statement. Two courses are open. My Lord Kali considered. Administrative order injunction passed upon hearing and without hearing.
No, Mr. Rai, can you say that this order is not appealable at all?
Yes.
Once there is a doubt as regards appealability and the alternative remedy of appeal is provided, why will you not approach the appellate?
Yes, my Lord Kali consider if that is why, my Lord, there are three aspects in a set of which I can approach the 227. My Lord, it is a jurisdiction vested upon the court which cannot be taken away. My Lord, the Supreme Court says there are three.
Right, but there is a distinction. There is a distinction between orders passed by civil court
An order passed by the
Other
statutory authority.
other tribunals.
Civil court is not absolutely barred. That is what.
No, the Supreme Court's subsequent judgments, especially in deep industries,
Yes.
and then one more, some Bhadra something,
Akin to bar.
says near total bar.
Near total. That is why. Now, my Lord Kali consider.
Industries, where it has been.
I'm
said-
conscious. Now, my Lord Kali consider.
They are also against in some arbitration proceedings. The matter had been taken to the High Court under Article 227 and thereafter Supreme Court, where the Supreme Court Justice Nariman's judgment was there.
Now, if you logically consider, there is a provision.
Tuticorin Education.
The arbitrator.
That is Tuticorin. Para 24, which is referred. Near to bar.
Yes.
Tuticorin Industry, Educational Trust. Para 24, Justice Bhattacharya.
Justice what is judgment? Considering the same, my Lord, it was it.
Near total bar. Para 24, near total bar.
Virudhnagar, yes.
Yes, near total bar.
Virudhnagar.
Now, my Lord Kali consider. You will logically consider the order of the arbitrator. Arbitral award, whether it can be challenged under 227. There, my Lord, the question cropped up. It was held, yes, it is not an absolute bar. But what are the parameters? Bad faith without jurisdiction. These are the two ingredients. If those ingredients are satisfied, I can approach the 227. Similarly, my lord, if your lordship kindly consider, kindly 34, 34.
Question is whether if you have an alternative remedy, whether the court will entertain.
Yes. Now, my lord, kindly
Maintainable.
that is what, my lord, if your lordship kindly consider under 39.4, whether the efficacy is alternative remedy. This is the question, my lord, kindly 39.4. Once. These are the, it is not a matter that I file an application and on the ground that it is passed without serving a notice. You have to recall. Without the same, I can prefer an appeal. Now, I can consider what is the scope of 39.4. An order for any injunction may be discharged or varied or set aside by the court on application made thereto by any party dissatisfied with such order, provided that.
Yes, that is an exception. You can be dissatisfied with an order for n number of reasons. Now,
No,
this is one of the reasons.
that is why, my lord, once it is in, that is why whether the court has jurisdiction to entertain that application with the service of notice of caveat.
Again, I say, Mr. Rai, that is again a ground of your dissatisfaction.
Yes.
No, you are dissatisfied with the order.
My lord,
Now,
can
if
you
you are
consider?
dissatisfied here. You are dissatisfied because of lodgement of caveat. The non-service of notice despite lodgement of caveat. A person can be dissatisfied because the court has been misled, for which the proviso says that yes, in case there is no notice and there is misleading statement or there is some misrepresentation, then in that case, Order 39 Rule 4 will provide. This also shows that merely because of no notice, Order 39 Rule 4 may not be available. That can be one way of reading it.
Yes, if that be so, my lord, I have to consider 148 way. Why the law of caveat? That is why, my lord, the law of caveat.
Only on the ground of non-service of notice, you cannot seek vacation of the order. You can seek it on merits.
Yes. Why? If there is notice is not, that is why, my lord, if you logically consider. Why the second proviso has been introduced? That where an order of injunction has been passed after giving a party an opportunity being heard, the order shall not be discharged, varied, or set aside on the application of the party, except where such discharge, variation, or setting aside has been necessitated by change in circumstances, unless the court is satisfied the order has been caused undue hardship. So there is two distinction. First is misleading because there is no service of summons or notice to the other side. He cannot come forward, save and except within this parameter. If it is not a case comes within this parameter, then my lord, what right this?
You are seeking setting aside or discharge or vacation of the order, being dissatisfied with the order. Why will it not come in?
Yes, well,
it may not come within the first proviso or maybe within the second proviso. But why does it not come in the main provision?
No, well, if you logically consider, if it is main provision only of the direct the notice of the application to be served upon the same is given to the opposite party, provided that if the proposed grant of injunction without notice to the application to the opposite party, the court shall record the result. Well, it's about the same. The court disposes of the application injunction in 30 days, where the injunction has been granted without notice to the opposite party. But why this court has debated restriction? Why with the notice and with notice? Without notice, only on the ground, my lord will find Order 13 1 and 2. Order 13 1 postulates whether there is emergent need.
Because the provision itself under 3 says that it can be done without notice if
but the caveat is not there. That is why
circumstances exist.
If the caveat is not there, if the order is passed, then my lord can consider there are two recourses open to a party. One, you have to go and approach on 39.4. These are the statement, or you can prefer an appeal. This honorable court, my lord knows very well, Justice Bhattacharya, Bhaskar City, that these are the two avenues open for you. Either 39.4,
Jitesh Pandey.
Jitesh Pandey, Gautam Hada, objection.
No, Gautam Hada.
39 objection দিয়ে দেবে যে শুনানি করবে চলে যাও না
Now, my lord, can consider. Here is the question whether the court has the jurisdiction to entertain that application. What is following from your lordship? Whether the court has jurisdiction to entertain the applications as after the notice has been served upon the caveator. Unless until that action has been done, the court has no jurisdiction to entertain that application. It is not a directed provision. Madam Kali, consider, today I filed a plate without deposit court fee. Court passes an order of injunction. What is the rule level sub rule D by Lord Kali consider? The court has no jurisdiction to entertain such plate. Then it is a case that I have to go before the appeal court for the purpose of vacating. The court does not have the jurisdiction to entertain. If the court does not have any power to entertain that application, whether any order passed is without jurisdiction, whether 227 is barred to challenge the same. None of these judgment which is fallen from your lordship for consideration is not a case, it is without jurisdiction. It is vacating variation 39.4. On the contrary, my lord, which my learned friend did not give answer is 90 CWN. Paragraph 2 is very important. The revisional court and what it said, it doesn't have any other option left upon the court to recall. It is the mandate given by the, there is no other option. So if it is brought to the notice of the court that yes, there is a caveat of the order, there is no other option but to recall the order and hear out the application of stress about giving hearing or whatever steps they want to. Here, my lord, contrary, not only refused to recall, but extend that subsequent extension which is followed by lord, Harrow Hall School is there, my lord, judgment, cardinal properties, which a subsequent extension is needed in the original goes, subsequent also goes. Is contrary to the in projects which is given. So that today, my lord has to consider whether the court has the jurisdiction to entertain that application. If it is entertainable, then my lord, appeal will come. If the court loses its initial jurisdiction to entertain, then whether can tutor is absolute bar. আবার
না না আমরা তুমি তো পুরো হাইজ্যাক করে নিচ্ছ সব।
আমি হাইজ্যাক করতে গেলাম জজ জিজ্ঞেস করবো বলে তো বললাম কিছু বলিনি
তুমি সিনিয়র লোক আমরা তোমাকে কিছু বলতে পারি But Mr. Mukherjee, I have not gone even gone through it. He will cite this judgment. Only allow him. I'll finish it 1 minute more. Lord, what I was not arguing before your lordship, Lord. Today we are faced with a situation where, my lord, a party consciously comes to court and insists that your lordship should exercise your lordship's jurisdiction despite there being an alternative efficacious remedy available to him. Not why these judgments have been rendered. Because your lordship's jurisdiction is not to be, my lord, exercised in all cases where there are other avenues open to the litigant. They should not bypass that and come and, my lord, ask your lordship to exercise. Today, no prejudice should be caused. I agree that there is a prejudice caused to them. They have suffered an injunction, good, bad, indifferent. They are aggrieved by that only. Had there been no injunction, they would not have been aggrieved. So they should approach to the proper remedy which is available. The statute has given them the remedy. Bypassing that, jumping a forum, coming to 227 court, insisting on exercise jurisdiction. Look, this is a case which could at best be considered to be an erroneous exercise of jurisdiction. The court should have put them on notice. The appellate court will decide. But not your lordship's court. In view of those two judgments, it is very clear. It is near to a bar. And what Mr. Rai is saying, they have not been able to show one judgment. However, the court has considered this aspect, that no, it is not appellable and revision will be entertained. Apart from that Guwahati, which says, I feel it is to be done.
Supreme Court deprecated.
So these are my submissions, my lord. And this is a very recent order. Let them go to the appropriate forum. If we lose, if we lose, if we win, if we win. But why jump a forum and come? And no prejudice, I repeat, would be caused to them. I'll allow him to cite this judgment.
Why, Milord? Mr. Roy is annoyed with me, Milord. I will quickly, Milord, finish it off. Milord, this judgment, Milord, they are citing a classic example like, Milord, 148A, non-service of notice, that gives, but elevated their status to such an extent that they can be not amenable, Milord, even in revisional jurisdiction. That's their case. Milord, kindly, Milord, takes up this judgment. This is also Guwahati, because, Milord, they have relied upon that Guwahati. This is, Milord, 2002 Guwahati, AIR 2002 Guwahati.
May I take a lordship leave?
Page 146. Milord, it's a case where, Milord, initial order of, prior to passing of the interim order of injunction, the learned judge directed service of notice, 3A compliance. Subsequently, Milord, without compliance of 3A, suddenly, Milord, an interim order has been passed. That was challenged in revision before the Guwahati High Court. So, Milord, it is also a case of erroneous exercise of jurisdiction. Once a learned judge has, Milord, directed a service of notice and thereafter, Milord, prior to, Milord, compliance of that notice, he exercised his jurisdiction. Kindly takes up paragraph 9 once. Oh, dear. Controverting the above submission, has your lordship got it in that paragraph 9? Controverting the above submission made by, on behalf of the opposite party, such and such has drawn my attention to the decision of the division bench of this court, delivered on such and such, wherein it has been held that order passed under Rule 3 of Order 39 is not applicable. Relying on a decision, Mr. Chaudhary has contended that since the status quo order has been passed without notice to the opposite party, it is really an order of injunction passed under Order 39, Rule 3. So, my lord, here also a case where, my lord, they want...
Our court has differed. This is not good law for that purpose.
Yes.
Order 39, Rule 3, there is no contemplation of an order. It is only
Yes.
the manner in which
So,
Order
my lord, it
39
ultimately goes back to 39, 1 and 2.
Order 39, Rule 1 and 2 is the provision under which injunction can be passed or refused. 3 is only the modus.
Yes.
How it is to be.
So, it is also a modus, my lord, where, my lord, there can be a process.
That is why I said that merely non-service of notice will not be a ground
Yes.
seeking vacation
Yes,
of the
Lord,
order under
I
Order
bow
39.
down. Lord, I bow down. Only to that, my lord, to buttress that. And, my lord, paragraph, my lord, 17, 18. Paragraph 18, my lord, again, my lord, relying upon Chelappan, it is a case, my lord, paragraph 17 and 18, wherein, my lord, the Guwahati High Court held the no. It is also comes within the purview of that. So, appellate remedy is available. So, revisional jurisdiction cannot be invoked. So, only with regard to this 3 point, my lord, and my lord, if your lordship, my last, on the last occasion, because it's ex facie, my lord, something has been demonstrated before your lordship that provision has been, my lord, interpreted by the learned judge while dealing with their vacating application of such a nature which is, my lord, against the statute. My lord, again, in my respectful submission, if your lordship takes up, my lord, page 77, they have annexed, my lord, the recent amendment of 148 capital A, and side by side, if your lordship place the previous provision, pre-amended provision, I say it cannot be said to be a perverse finding of the learned judge. Why? Because my learned friend says the entire, Lord, intention or the entire object of lodging caveat will be frustrated if it can be interpreted like the way the learned judge has interpreted. Kindly, my lord, takes up this. My lord, page paragraph 148, sorry, section 148 capital A and page 77. If your lordship keeps side by side, then, my lord, the original pre-amended provision is subsection 2, may I place, where the caveat has been lodged under subsection 1, the person by whom the caveat has been lodged, hereinafter referred to as a caveator, shall serve a notice to the caveat by registered post acknowledgement due on the person by whom the application has been or expected to be made under subsection 1. It stops then and there only. What is, my lord, amended? Insertion. Kindly takes up, my lord, the page 77. Just, my lord, the second clause 1, Roman clause 1. The section 148 subsection 2 for the words registered post acknowledgement due, the substitution is the word speed post with registration and proof of delivery shall be submitted. So this proof of delivery was neither there, my lord, pre-amended provision. So it is one of the way the learned judge has interpreted. Whether that interpretation is wrong or right, it is not so perverse, so that the revisional jurisdiction again, because, Lord, I am submitting in their favor, because, Lord, the appellate court, the jurisdiction is more wider. Today, under Article 227, your lordship. Yes, that's where. If this is my submission.
Now the judgment relied upon by my learned friend, can you turn to paragraph 13?
Yes.
Since this court is bound to follow the full bench decision in Akmal Salih's case, my lord got it. There can be no escape from the conclusion that the impugned order is intended and appellable order. It is important to note that under 39(3), a court merely decides whether to grant injunction ex parte or after giving notice. If it decides to give notice and pass an order of injunction after giving notice, the power is really exercised under Order 39 Rule 1 and 2. If the court, however, decides to pass injunction without giving notice, then 2. The court granting really follows the Order 39 Rule 1 and not 2. Thus, Order 39 Rule 3 merely gives option to the court whether to issue injunction after giving notice or without, merely gives option to the court whether to issue injunction after giving notice or without notice. Here, my lord, it is left to the court to consider whether the ex parte additive order injunction can be granted or injunction can be granted. There, my lord, the court has the discretion. If it is without notice, the remedy lies under 39(4). That is why on the very beginning of this judgment, which my learned friend introduced, two options open: either go before the court, 39(4), or prefer an appeal on order 43 rule 1 some rule R. But here is the right of a court to entertain that application. That is the only question which is come forward. If you logically consider, yes, judgment, Sukumar judgment, with the cost of repetition, my lord, I mean again relying upon the judgment 90 CWN, my lord, that portion. Rule of caveat are meant to give opportunity to the party to contest any claim of injunction before it is made. If, as in present case, caveat was actually lost before the order was sought for and has been found by the learned judge, he could still proceed to say that he would proceed on the erroneous endorsement assisted register. The only course open to the learned judge should have been that was the defect was pointed out to recall the order forthwith and hear the matter on contest. There should be the procedure followed to fulfill the real object of the rule of caveat. We are therefore unable to sustain the order. Possible we set aside the order, we allow. So this is the only option. This is the dictum. So therefore, the court, as soon as that is why, my lord, I brought to your lordship notice the earlier order passed by your lordship while directing the matter to be reheard before the, because the objection which is.
Here is a case, Mr. Roy is not citing this judgment to be said that in every case, whatever the caveat is, here the court has gone into the merits. His objection has been taken into consideration. Amended provision has been explained and said, no, I am not going to vacate. So it is not a simpliciter case that citing this judgment for everything, once the caveat is being lodged, so in any order.
Whether the caveat has been lodged or not.
This is something.
Whether my learned friends, what is my learned friends suggestion? Whether the caveat has been lodged or not. No answer is coming from my learned friends whether the caveat has been lodged or not. No. Because the order itself will prove that one, there is an endorsement of the caveat, and another, there is no endorsement regarding the caveat. What special procedure adopted by the court for accepting the earlier caveat to be noted as the caveat when the same procedure was followed? If you logically consider the order impugned, which is the injunction order was passed, I don't want to. This revision application to the. Second volume and last page. Injunction order. Injunction order. Injunction order.
Page?
Yes, my lord. Page 200.
Page 200, yes. Page 200 is this court order.
No, no, এই অর্ডারটা না, এর আগের অর্ডারটা। One minute, my lord. যেটা অর্ডারটা পাস করেছিল ইনজাংশন, সেইটা কোথায়? One minute, my lord. Ranveer. Injunction, initial order injunction. 90, na?
90.
90, my lord. I've been informed by 90.
Page 90, yes.
এখানে হ্যাঁ, কিন্তু না ওই যেটা ক্যাবিনেট নোটটা এই যে if you logically consider page 90 first, the identifier is moved. Seen the caveat note of Sesada without his signature. Seen the caveat number 1885 of 2025. Pause there for a moment. So one caveat has been recorded by Sesada. Now, apropos to this, my lord, can you consider page number caveat 221, no? 221. এটা না আবার ক্যাভিয়েটের কপিটা যেটা আমরা অ্যানেক্স করেছি। Yes, my lord, can you turn to page 150?
150.
Yes. Now, my lord, can I turn to 156? Yes, my lord. Caveat lodged 18.
Page 153.
156, my lord. Because these are the application I have annexed. Apart now, my lord, the computer registration number. 1897, my lord, got it at the left, second column.
Yes.
Now, can you turn to 157? These are the details of the caveat lodged. So, my lord, I put this question to myself. What is the special caveat or format has been adopted by that one caveat and this caveat? Because, my lord, logically is the logic of caveat, my lord will find is governed under the civil rules and order. What on the earlier occasion, my lord was pleased to put the question how it can be reconciled between CPC and civil rules and order. My lord, can you consider 129 of the Code of Civil Procedure? The power granted to High Court for framing the relevant rules. My lord knows better than us, my lord. On the basis of
appellate side rules will prevail over CPC.
And the High Court rules and the subordinate court rules also framed by the full court of this High Court.
Yes,
It is for supplement, not overriding, supplement.
Yes.
That is why, my lord, can you turn to that is specific provision was brought by the High Court. 40A. That is the specific provision has been brought, my lord. How the caveat to be filed. Now, my lord, may I hand it over to your lordship, my lord?
40A.
40A. It was brought in the year 1985.
Yes.
Two. কোথায়? হ্যাঁ? কোথায় যাবো? ওইখানে চলছে। পাশে দিয়ে চলছে। Every caveat on 148A shall be appointed by postal receipt in proof of service of notice of caveat by registered post. Yes, with acknowledgement due to the person to whom the application has been made or is expected to be made. The caveat is been lodged under subsection 148A, provided that in case where the caveat has been lodged in a pending proceedings, procedure are there. So I have to comply with the provision which has been laid down. On the basis the caveat has been lodged. There is no indication whether there is defect in lodging of caveat. That is why I put this question to myself. What prompted the learned trial court to accept the earlier caveat as valid and my one is, according to them, the considering the amended provision is invalid. So the same procedure was adopted for filing of both the caveats. The question is 227 is applicable or not, my lord. Whether the appeal is efficacious or alternative remedy and whether the 226 is absolute bar or akin to bar. What is followed from your lordship? The akin to bar in entertaining this. 39. Appeal rests on the provision, my lord, an illegal exercise of power. It could have been understood that yes, the court has passed an order of injunction which could not be passed on the basis of the amendment made in that application. Court has passed an order which is otherwise bad in law. I could have challenged that. My case is that the court cannot entertain that application. Order passed will subsequently later.
But Mr. Rai, can you not take this point before the appellate forum? You can take this point also before the appellate forum. This is available.
No matter if it is without jurisdiction, whether I have denewed to move this application to other 226.
That is where
the Supreme Court says, well,
it says that when there is a provision for appeal, it operates as near total bar. That is the language.
Yes, that is why
it does not only remain confined to self-imposed restriction, judicial discipline. It goes 1 to 3 steps further and it operates like a total bar.
Yes.
Now, in such a case, yes, if you could have convinced the court or you can convince the court that yes,
this is the error apparent.
Is not available. Then in that case, yes, you can get in. then your argument will have to be that Order 39 Rule 4 does not apply to your case.
Yes, that is why, my lord, the Honorable Apex Court has said, my lord, if you today, my lord, this, that 227, arbitrator, my lord knows better than us, arbitrator, section 34 is the ground for appeal. Then, my lord, it says the arbitral award can be amenable to 227 under what concepts? Without jurisdiction, patent error, or bad faith on the face of the record. Here we are arguing on the fact it is a patent error regarding assuming jurisdiction in entertaining that application. On the face of the record, my lord, face of the record on the basis of which it can satisfy your lordship that yes, this application cannot be entertained without complying that provision. So, well, the one case, my lord knows better than us whether there is a dispute, whether this arbitral award can be amenable to 27.
It is not arbitral award, it is about arbitral orders.
No, arbitral awards. Order. No, 16 is the arbitral award is there, but the one case I forget to. They are
construction, Bhuven.
No, National Highway. This Hakim. Yes, I grateful to your lordship, my lord. Hakim the first court for consideration. Statutory arbitration, arbitration law will apply. Yes, with a fact. So national highways,
land acquisition,
there is an appeal. But yes, you can challenge, but whether it can be modified or not, you cannot. You have to apply the provision as laid down in Arbitration Conciliation Act. Two exceptions have been carved out. One can recall the two exceptions. One is bad faith without jurisdiction. Whether this entertaining this application with the service of notice to the other side, in spite of logic of caveat, it turned to be without jurisdiction. If that be so, then I have every right to knock to the door on Article 227. Hakim is, why not? I'm relying upon Hakim on that score. That yes, 227 is available, provided you have to satisfy this condition. My lord, it is also held, we have shown to your lordship, that notice of logic of caveat without notice amounts to passing of an order amounts to violation of national justice. If that be so, my lord, whether the principle of national justice is violated, whether I have to avail the alternative remedy, I am not in a position to avail the constitutional remedy under 227. It is my national justice has been violated. If your lordship wants, I can hand over the Hakim's judgment to your lordship.
Yes, closing.
Yes, my lord.
Nothing remains to be argued.
Other matters just called.
Third. Customer yes.
Balu and say Kalipodo Rai.
Law has left. And if I may come back tomorrow, Milord, if he may give me a copy, Milord, so that I can also.
Kalipodo Rai has made it.
So that I may also.
Tomorrow.
Even
tomorrow.
Yes.
কালকে উপরে রেখে দেবেন টপে 10:30 লিখে রেখে দেবেন অ্যাসাইন ম্যাটারেস তো নিচে থাকবে শুধু এটা 10:30 লিখে রেখে দেবেন এটা নিয়ে নেব Yes.
My lord, under very helpless and precarious condition, my lord, I have been compelled to mention this matter.
This is for the correction.
In-
My lord, in the last line, the petitioner shall take appropriate steps for
Because you have already
publication.
published.
That was published, that's why it must be omitted, and kindly give us direct to proceed with the probate application further.
The matter has been mentioned for correction of a mistake in the order dated
Appearing for issuance of citation. The details of the legal heirs are given in paragraph 4. The testator had passed away on 4th September 2020. Will is a registered will of 21st of July 2003. The husband and one son has predeceased the testator.
लिखे नहीं this
Yes, yes.
Yes.
I'm for the petitioner, my lord. But testator made the will, my lord, on 28 January 2016, and he died 5th November 2016, my lord. And she had his wife, son, and daughter. By the will, my lord, he gave his properties to her wife to life estate, and after her death to the son and daughter. Her wife and son has given consent, my lord, but daughter did not give consent, my lord. Special citation issued, my lord, but no case has been filed by the daughter.
One of the sons is the executor. Wife, one son, and one daughter.
Yes, ma'am. Son is the executor, my lord.
আরেকটা affidavit of না consent তো দুজনের লাগবে, affidavit of consent দুজনের লাগবে তো। একটাই তো affidavit of consent আছে, দুজনের মধ্যে একজন এক্সিকিউটর, দুজনের কনসেন্ট লাগবে।
Lord, probate of a will, my lord, because the copy of the original will was lost. Therefore, my lord, we are proving it in solemn form, my lord. It's consent by all the legal heirs. My lord, the evidence has been given by the attesting witnesses as also the executor. And now the executor has said, my lord, the will was lost.
The copy of the will was lost.
My lord, original copy was lost, my lord.
So you produce certified copy.
We have produced a certified copy. It's a registered will. So, my lord, certified copy of the registered will has been produced. The lordship will only see, my lord, the order of 30th August 2024. 30th August because it has to be in solemn form because of the order, my lord, which was passed. 30th August 2024 by Justice Patnaik.
30th August.
30th August.
कोई ऑर्डर 30th अगस्त तो नहीं।
তাই তো দেখছি 30th August. But I have a hard copy of it.
একটা কাজ করুন, ডকুমেন্ট গুলো একটু অর্ডারে করে নিন, not today. Let the documents be in order.
No, the order is there.
Evidence গুলো, no, I have to see my records in order. You have waited for so long, wait for one more day, let the records be in order. সব ডকুমেন্ট গুলো এক জায়গায় করে দিন, এভিডেন্স যা আছে এক জায়গায় ঠিক করে দেখিয়ে দিন।
Lordship, this is my application for grant of probate. Lordship, the deceased died on 22nd July 2013 after publishing his will dated 3rd February 2013, leaving behind his widow and 2 sons. The elder son is the executor.
And the wife of the deceased?
Subsequently, the wife died on 8th May 2016. The death certificate is filed before your lordship.
The wife predeceased him.
Subsequent to the publishing of the will, the testator died, leaving behind his wife and 2 sons in the year 2013. Subsequently, in the year 2016, the wife also expired. So only the 2 sons remained. The elder son is the executor. The younger son has filed his consenting affidavit.
Where is the death certificate of the wife?
File করা হয়েছে ওটা। ওটা চিঠি করে file করা, of the wife. And one of the attesting witnesses has also filed his affidavit. Assets are within and outside Lordship.
Why don't you file this copy of the death certificate by way of a supplementary instead of filing it?
Lordship, during scrutiny, Lordship, I was advised by the, it was my fault that I should have filed, it should have been filed, Lordship.
File it by way of a supplementary. It can't be like that. By way of a letter, it can't be. File it by way of a supplementary. Bring it on record. We'll pass orders. Let the procedure be right. It shouldn't be by way of a letter, because this is something which should not come from you. It should come from the person who is seeking the grant. Right. File a supplementary.
Lordship.
How soon can you do it?
1 week's time at least, Lordship.
As prayed for by the learned advocate appearing for the petitioner, leave is granted.
Uh, 10 days would be 13th. So any day after 17th, Lordship.
After 2 weeks. Let such supplementary affidavit be filed within in the meantime.
Your Lordship, this is my application for grant of probate. Your Lordship, the testator died in the year 2019. The will was published in 2012, 21st December. It is an Annexure A. Death certificate is Annexure A, page 12. Will is, Your Lordship, Annexure B on page 13. Your Lordship,
Madam, just 1 minute. 1 minute.
yes, Your Lordship.
What about the wife?
Your Lordship, wife passed away in the year 2021. The death certificate is annexed as Annexure E, page 19, Your Lordship. Son is the sole executor and the daughter has given affidavit of consent. And both the attesting witnesses file affidavit, Your Lordship.
Anjanda.
Bro, this is tired, my lord, leaving behind his wife and daughter, my lord. My executor is is the brother of the deceased, my lord. Joint executors. Yes, ma'am. Second paragraph, first page. Yes, ma'am. My lord, they are not insane or they are not insane, my lord, or lunatic, my lord. My lord, they came to this honorable court, my lord, they found the affidavit before the commissioner, my lord. If your lordship so wish, I can produce them, my lord, before lordship, my lord. In the meantime, the wife has died, expired, my lord. I can produce you daughter before lordship. Your lordship examine the daughter, my lord. My lord, she knows the wife. In the meantime, wife has expired, my lord. On 2nd of November 2024, she has expired. The wife. Lord, I have the death certificate, my lord. Yes, ma'am.
Right, please, my lord. This is my application for grant of probate, my lord. The executor, my lord. My lord, the executor is the husband of the deceased district, my lord. The will is of 12th September 2022, my lord. And my lord, three heirs, my lord, the husband and two sons, my lord. Both the sons have given their consent affidavits, and my lord, one of the attesting witnesses have annexed, my lord, have given an affidavit in support of the execution and due attestation of the will. Yes, my lord. Yes, my lord. These are the only heirs. Now, the husband is the executor, my lord, and the bequeathment, my lord, is happened to the husband, which, my lord, thereafter will devolve as per ordinary succession.
So this is my application for grant of letter of administration, my lord. The petitioner is the, my lord, sole beneficiary and the wife of the testator, my lord. My lord, apart from this petitioner, my lord, being the wife of the testator, my lord, there are two other legal heirs, my lord, the two sons, my lord. The sons have, both the sons have already filed their consent affidavit, my lord. I have, there's a doctrine of Musa, my lord. A Mohammedan has been restrained from bequeathing his entire property without the consent of the other legal heirs, my lord. In this event, my lord, there are only three legal heirs upon whom the property could have been devolved in case of intestacy. Yes, sir, I have obtained a certificate, my lord. This is the original certificate. That I. Yes, my lord, I'll file a supplementary affidavit. Kindly grant me leave to file the supplementary affidavit, my lord. Farazram, I am referring that document, my lord. Grateful, my lord. Issuance authority, my lord. Yeah, my lord, this is registrar. लिखे दो.
And for the petitioner lordship, this probate application is ready for final disposal. May I present this application? The deceased testator left behind his last will and testament dated 18th February 2012. It was a registered will and it is annexed as Annexure A to this petition. He died on 16th April 2019 and the death certificate is Annexure B to this petition. At the time of his death, there were 5 legal heirs. His widow, 1 son and 3 daughters. But before this probate application could be presented, the widow died. So only 4 legal heirs remain. It has been filed, the death certificate. It was filed in the department, Lordship. Very well, Lordship. 1 week.
Application for grant of probate. My lord, there are 4 heirs, the parents, the widow, and a minor son. The widow has given the consent on behalf of the minor son. Assets are both within and outside this state. There are 2 attesting witnesses, both have given their affidavits. Minor son was born in 2010. He is now 16 years old. Actually, আলাদা আলাদা বানাচ্ছে।
But my application, my lord, for grant of probate, my lord. All the legal heirs have given consent, my lord. Son. My lord, I have preferred an application, my lord. My lord, I'm sorry, my lord, I'm sorry. My lord, there was an order of the Honorable Single Bench, my lord, that since there are a few properties which is outside jurisdiction, my lord, and subsequently, my lord, that order has been turned down by the division bench, my lord. And in the juncture, my lord, I have preferred this application, my lord. Today, my lord, yes, my lord, I'll not press this, my lord.
Application 2 is a similar application as in item number 13, my lord. The application was filed in April. My lord, the PLA may be listed, my lord, in due course.
Lordship, Mr. Saha had concluded his arguments.
The 15, I have been instructed to appear in this matter. My client has obtained the probate. They have filed this. Yes. My lord? Yes, yes. Only, my lord, only one thing, my lord. If your lordship kindly takes it, I am on the locus. Because why I am saying so? That is because your lordship probably subject to correction by your lordship. Subject to correction by your lordship, my lord. Probably your lordship has directed us to file a short affidavit in respect to dealing with all the points. Yes, but yes. Injunction. Then I'll submit 10 minutes if your lordship kindly.
Yes.
My lord, no, my lord, sorry, my lord, it was my fault, my lord. It was my fault, my lord, I could not appear, my lord. My lord, what is here, my lord?
Today, I'll be praying that your Lordship provides interim protection at least for the time being.
Interim protection, my lord. My lord, first of all, my lord, they are claiming being for revocation of the probate on the ground that they have a slightest of interest whatsoever. Now, my lord, what is the slightest of interest and based on what document they are claiming? If my learned senior friend has argued in respect to that, my lord, they have a slightest interest, then they have invited the court to look into the document on the basis of which they are claiming for revocation, my lord. Well, if your lordship sees the document, it's an agreement to enter into an agreement.
No right hand.
Well, why I am saying so? Well, in a probate proceeding, subject to correction by your lordship, caveatable interest is the sole intention when a probate application is filed. Whether, my lord, I have served to my legal heirs, whether, yes, madam. No. No. He has cited the judgment that 2026 Supreme Court, if your lordship sees in paragraph 21. Well, then he has to show. Then what he has to show, Malad? Malad, if your lordship, Malad, if your lordship sees, Malad, Malad 263, if you yes, well, he has to show, Malad, that at least he has an interest, Malad, he is an outsider. Malad, today, Malad, the probate, Malad, I have obtained, Malad, the daughters came here, Malad, they have given the consent. But the lordship will kindly see the dates.
Lordship.
Yes. Then, my lord.
Lordship has extensively heard the matter.
May I ask this question to myself, my lord? In a probate proceeding, well, if there are three attesting witnesses, well, if one attesting witness comes before your lordship and he, my lord, has filed an affidavit, well, that is enough. And that is not the daughters. Lordship will kindly seize. Well, 68 of the evidence that lordship knows much better than me, my lord. Well, no, I'm not shouting, my lord. Very well. Very well. Very well. Very well. My lordship, I'm sorry. My lordship can ask. No. Well, I'm very. Well, lordship is well, unconditional apology I'm taking. Well, no. Well, it will be very difficult for me. Well, lordship will kindly, well, I'm unconditional apology. Well, only thing is that, well, whatever the question has come from your lordship, well, is this application is maintainable in the eye of law, at the first threshold also, well, that is my first point, man. If your lordship allows me. Very well. No. Well, I'm ready to answer, madam. Well, your lordship has asked me. Well, I have only said, madam, the documents they have submitted, madam, whatever may be. Well, kindly don't take me amiss, madam. Well, this will be an impossible task. Well, lordship will kindly take, madam. Motion for take your order. May I, the basis of the document, they are saying, if your lordship kindly takes the registration act once, I am carrying before lordship, why I am so, I'll clarify that situation, man. If your lordship allows me, man. Kindly, don't take it. Section 17, if your lordship kindly takes 1B. May I, madam? Well, if you I'm unconditional. Kindly, don't take me amiss. Total, I will not submit. It is wrong impression. I'm not that type of person. I have full respect on this honorable court. Only I have tried to convince upon the court that this is not maintainable. Well, I bow down before your lordship. It's an unconditional apology. Lordship will kindly grant that, man. Lordship will kindly takes, man. Documents of which registration is compulsory, madam. B. Other non-testamentary instruments which purport or operate to create, declare, assign, limit, or extinguish, whether in present or in future, any right, title, or interest, whether vested or contingent, of the value of 100 rupees and upwards to or in immovable properties. So in this case, registration is necessary. Now, if your lordship kindly takes 17(1)(a) 5. Registration is necessary in respect. Yes. Well, why I am showing this document, man? Why section? Well, my be in respect to all instruments other than non-testamentary. Lordship can see other non-testamentary instruments which purport or operate to create. Yes, because why? Why? Yes. Yes, 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 yes. If your lordship kindly takes their document on the basis of which they came before your lordship. And that is at page 26. Yes, ma'am. For volume 1, my lord. Yes, yes. Now, if your lordship kindly sees the classification of the agreement, it says agreement for assignment, transfer of lease. So, my lord, this is an agreement to enter into an agreement. Well, why I am saying so, my lord? If your lordship kindly takes along with the Registration Act, my lord, 17(1)(a) 5 of Registration Act only, my lord. Yes, my lord. 1 capital A, my lord, 5, Roman 5. 17(1)(25). Yes, sorry, man. I'm extremely sorry. 2(5). Extremely sorry, man. Why I am saying so, man? Any document other than the document specified in subsection 1A, not itself creating, declaring, assigning, limiting, or extinguishing any right, title, or interest of the value of 100 rupees and upwards to or in immovable property, but merely creating a right to obtain another document which will, when executed, create, declare, assign, limit, or extinguish any such right, title, or interest. So my respectful submission before your lordship, this is a document under 2(5) to obtain an agreement for lease that will be done consequent to all the payments and all the permissions that will be given by the UD, because this is a government land, it's a leasehold property. Right. So, my lord, created. If I can correctly interpret the section, my lord, 17(1) is a section, my lord, which gives the registration is mandatory in respect to all this. If not, my lord, then in a case, in a situation when a party is entering into an agreement to enter into an agreement, that is 2(5), then my lord, no right is created. Well, once no right is created, so my lord, the document which they have placed in page 26 of their application for revocation, my lord, this document does not give them a slightest of right also, even to come before your lordship and take this application for hearing. If in a situation, these are registered lease, even if has been executed by the daughters or mortgage for sale, then I would have not opened my mouth in respect to because a slightest of right that will be decided in the trial. I would have not opened my mouth. In this situation, even the judgment which has been cited before lordship, as per I have just whatever collected information, that judgment itself, wherein the testator himself executed a sale deed in 1976, and also prior to that a will was executed in favor of one daughter. The daughter came after 33 years before the probate court without citing his own brothers. That is a specific finding of the court, that the citation is mandatory in a probate proceeding. If it is not done to the legal heirs, then it's bad, absolutely bad. Yes, yes. Very good. So, my lord, if today your lordship is interfering in respect to if they are pressing on this application, then first thing they have to show before your lordship, just see, I have a right, whatever may be, even if it is obtained subsequent to the death of the original testator, then also yes, my lord, right in respect to subject to correction by your lordship, my lord, I have a right, my lord. Yes. I might have a right to enter into a house, but I might not have a title because it's my father's house. I have a right to enter. Yes. 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 If this is the document he is producing, my lordship knows, the person who died tested. If he died tested, so the normal rule of succession and the Hindu law doesn't comes into play. So it's the Indian Succession Act will follow. But in this situation, where the daughters has come before this honorable court, even a mutation application has been filed before this honorable court, where the daughters has come and given consent on affidavit before before the UD.
Commercial.
Yes, madam.
While probate was pending.
Yes. Yes. I'll try to answer, my lord. Whether, if today, my lord, a person X gives a bequests a will in respect to Y, whether, even if I take, my lord, the final outcome. In that situation, my lordship will see they have already, my lord, proceeded in criminal proceeding before the court, and they have obtained bail. Now, in a situation, they have also proceeded under arbitration proceeding that is also pending, but they can always claim damages against that. Now, in a situation today, they have filed this application. If your lordship kindly takes the one document, lordship will see UD document. Well, the document filed before the urban development, the date is very important. Why I'm saying so, man? Yes. Well, page 39. কোন ডিস্ট্রিক্ট কত
সেকশন 9 সেকশন 9টাও দেখানো সেকশন 9টা তার আগে
21 এর ডেটটা কোথায় লেখা
সেকশন 9টাও তো আগে করে তুমি যদি
বের করো না বসো lawsuit will kindly sees this application was filed on 21st August 2023. That is their claim. অর্ডারটা যেটা বলছি তখন সেটা বের করো so it's an impression has been given to the court that the these two ladies went before the UT department. Now, if a lordship kindly sees Justice Bhattacharya's order, my lord, I'm just reading for your lordship and I'll hand it over a copy. Order in section 11 proceeding. Section 11 proceeding, it was specifically quoted. Yes. 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 So in that case, it appears from the documents from the Canada invoke. Yes. It says, and notice under section 20, well, if your lordship, well, I could not, well, if your lordship, well, it's only for recording of your lordship. Section 2, yes, well, lordship will kindly take this. This was not annexed before your lordship. Yes, well, I would just want to show, and if your lordship kindly sees that, well, the date of the section, it appears from the documents placed before the court, the petitioner invoked the arbitration. Yes, well, it's first paragraph, well, the second page, well, I am reading, well, it appears. Well, it appears from the documents placed before the court that the petitioner invoked the arbitration agreement page by way of a notice dated 22nd August 2023. This is after the petitioner applied for interim protection before the Rajarhat Commercial Court 7th August 2023. The order of injunction is on 7th August. Now, in 7th August to 23rd August, they have initiated section 9 proceeding before the Rajarhat, and this is their case, that they have invoked section 21 notice on 22nd of August 2023. Then how could this letter be deposited on 21st August 2023? Yes, because when there is a dispute between the parties, will that party go on that office on 21st August when an injunction is? Yes, yes. Well, this is all. Well, even if that agreement is entered into, then today, if I say the person who is responsible for all these things, the daughters, if today they, that, yes, yes. Also interesting. Yes, in intercity. Yes. Yes. Now, my lord, if you allows me, my lord, if I think in a different way, my lord, the will was executed by the testator in 2020, whereas there are 3 attesting witnesses. Yes, yes, ma'am. Yes, ma'am, I'll definitely do. If at that point of time, there were 3 attesting witnesses. Why I am pressing on this? The daughters never objected to the execution of the will, the probate. Yes, yes. My learned friend was there. Yes, yes. In that case, lordship has to also see whether today if somebody else also comes, the daughter, yes, ma'am. Now, my lord. Now, my lord, your lordship knows that there is a stay in respect to all this transfer proceeding now in Salt Lake Properties. That is there. That is there. My learned senior friend also cannot deny on that. I can show your lordship the order also. entire stay has been granted in this. Very good. Yes, sir. Yes, yes. Lordship will kindly takes it on thereafter tomorrow. To be mentioned, I'll come with the instruction. If your Lordship, I am the. But tomorrow I have some personal difficulty. Next thereafter tomorrow. Lordship kindly takes it. I'll just come with the instruction. Written instruction.
Day after tomorrow, I will be in some difficulty. I will not be in Kolkata.
শুধু স্যার ওই ইনস্ট্রাকশনের জন্য যে একটু
We had
stay
5 days to take instructions.
No.
Yes.
Yes. Yes. Yes. My lord, if your lordship, your lordship can record my submission in that manner. Already there is a stay in respect to entire transfer proceeding in the Salt Lake.
That stay if it's lifted tomorrow because my lord, there is a lot of my lord activity going.
Supreme Court is pending, my lord. That I can vouch on that, my lord. That is there.
It is on record. I'm just not there, my lord, day after tomorrow. That's all. Yes, anytime.
Any day. But lordship, Thursday,
Yes,
lordship
yes.
takes it. Well, I'll. No. I'll not.
গৌরব
This is my application for recording death of the one of the legal heirs of the deceased. The husband of the deceased, Kosturmal Mehta, died on 3rd June 2025. My lord, the death certificate of the Kosturmal Mehta has been annexed to this application, being annexed at B. My lord, that. My lord? No. All they have given consent. All they have given consent during the pendency of the probate application. The husband of the deceased died. Only for recording the death and deletion of the name of his husband from the probate proceeding, the instance application has been filed.
we are not in a position to produce the death certificate. So we ask that for the time being, let the matter